All right, welcome everyone to, this is the December 5th meeting of CS Bars. And it's my pleasure to welcome you. My name is Greg Brandis. I am not the chair. Our chair today is away. And so I'm trying to fill in for the chair if I can. And so let me begin with just a couple of minor logistical announcements. Thank you. Let me begin with just a couple of minor logistical announcements. One of them is that we're scheduled today from 10:30 until 3, and we'll have a special set at 11 a.m. for our discussion of the demographics and data collection issue that is on our agenda. Because we have some staff members who are here for that purpose, and we'll try to ensure that we are efficient about using their time. I also wanted to mention that our guests are pleased to have our guests joining us for our meeting. There will be opportunities for public comment on matters that are before the committee, and we'll take that in a couple of ways. We'll take some immediately, and then we'll offer the opportunity here and there as respects particular issues in which there may be some comment. I also wanted to mention that lunch will be provided for members of the committee and staff members. Our guests are, of course, welcome to eat the leftovers if there's anything left, but let's be sure we're accounting for the staff members and others in respect to that regarding the lunch, which will be in the room next door something around noon, and most likely for purposes we'll take a break for that about that time. Also, in regard to public comment, if I could ask that if there are public comments, that people keep them to a reasonable amount of time, 3 minutes or so. We appreciate that as well. In the room present, we have certain members of the committee. We also have some members joining us by phone or online today. Welcome to them as well. And we also have a new member who's joined CS Bars with his first meeting today. His name is Greg Murphy. He's extremely well qualified. Greg, would you just spend a second to talk about your background for everyone's sake, kind of introducing yourself?
Let's see, I had to be smarter than the device here.
That's that little thing, got a green light. You're good.
Oh, there we go. Okay, good. Well, thanks, Greg. Greg Murphy, I'm from Montana, so who am I here? I have a long history of pro bono work in bar examining and law school accreditation. That's the among positions I've held as chair of the Montana Board of Bar Examiners, chair of the Multi-State Bar Examination Committee, chair of the National Conference of Bar Examiners, chair of the ABA Law School Accreditation Committee, chair of the Council, the Section of Legal Education. You get the idea. More recently, I was appointed by the California Supreme Court to the CAPA, the working group, to look at the job analysis for as part of the examination of the California bar examination. So I'm on that group. I'm not a Californian, obviously I'm a Montanan, and the Supreme Court and now apparently the Board of Bar Examiners has decided that I could offer something to you, maybe from the outside perspective coming in, and I hope I'm valuable to you. I believe in all this national work. I still believe in the federal system, and so I understand this is a California deal. I may offer some comments on how I think you might benefit from the national experience, but I appreciate the opportunity to be assistance. And in real life, I practiced law in Billings, Montana. After law school, I graduated. I clerked for a Ninth Circuit judge, went back to my home state where my wife wanted to live, and joined a law firm. It's a good law firm. One of my former partners is chief judge of the Ninth Circuit now. And I had a general civil litigation practice, and I left that in 2011 because people were asking me to do more mediating, and that's what I do. That and pro bono work for the poor is what I do full time.
It's terrific. Thank you very much. We're really, really pleased to have you join.
Thank you.
Trying to be a part of this effort. Let me also ask everybody to kind of introduce themselves to Greg, everybody on the committee and the staff, just very briefly. He may know some particularly staff members already and some members, so we shouldn't be elaborate about this, but let me begin with our deans on the phone, because he's certainly not had a chance to see you. How about let's start with Dean Frickberg.
Sure. Jay Frickberg, the University of West Los Angeles. My background has been in education since I graduated. I'm also a recent graduate of our Assessment Leadership Academy within WASC, and I'd like to bring more of the assessment devices to higher education, specifically law schools.
Thank you, Jay. And Dean Pritikin.
Hi, Greg. I'm sorry I'm not able to meet you in person this time. I'm the Dean of Concord Law School for University Global. I've been in this capacity for about 3.5 years. Before that, I was a professor and administrator at a traditional ABA law school for 12 years, and very happy to be in this role as Dean and on the committee. Very interested in innovation, legal education, and access to justice. And I welcome you to the group.
Thanks, Marty. Now, we also, I think, have on the phone some other members of, for example, the Committee of Bar Examiners. Do we have any members of the Committee of Bar Examiners on the phone?
So we do have Jim Fox, the Vice Chair of the Educational Standards Subcommittee, participating in his role as an observer and member of the public, and in support of the committee work of CS Bars.
Okay, thank you. And then let's start in the room. Kareem, do you mind?
Of course not. Of course not. Mr. Chair, my name is Kareem Gongora. Sorry, it's a little loud. I'm actually from Southern California, from an area called the Inland Empire, and I am a public member to the Committee of Bar Examiners, and I've been on it for, I think, 1.5 years now. And in my background is I've served at the local level, county committees, and on other state capacities. So happy to be here and welcome. Thank you.
And Brian, let's go over to you. Dean Purtell.
Good morning. My name is Brian Purtill. I'm the Dean at Empire College School of Law in Santa Rosa as of August 2018. So I'm heading into my second year of that job. I spent my career in Sonoma County and counties north of that, Sonoma, once in a while in Los Angeles, as a general civil litigator and a mediator since 1920 or 1996. I spent the last 10 years of my litigation career with a local firm in Santa Rosa up until 2014, at which time I got out of litigation, focused on my mediation, and then took over as a dean. So I was told that if you want to learn what a dean has to do, you need to jump in with both feet, so that's why I'm on this committee. Nice to meet you.
Thank you.
All right, well, then let's have our staff introduce themselves.
I'm Caroline Holmes. I'm an attorney with the Office of General Counsel for the State Bar, and I provide legal advice and support to CS Bars and the Committee of Bar Examiners and other admissions-related entities. Nice to meet you.
Thank you. Nice to meet you.
Hi, Greg. I know we've met before. I'm Amy Nunez, Director of the Office of Admissions, and I've been working with Greg on CAPA as well.
And I'm Natalie Leonard. I'm staff in the Office of Admissions, staffing CS Bars, and working with the law schools.
All right. Well, now you've got a good briefing on everyone around the room. Thank you. Thank you to everyone. Well, at this stage, we should probably take the actual formal roll and get the formal part of the meeting started. Natalie, you want to take the roll?
Sure. Chair Jackie Gardina. Acting Chair Greg Brandes.
Here.
Brian Purtill.
Here.
Kareem Gongora.
Present.
Greg Murphy.
Here.
Martin Pritikin.
Here.
Jay Frickberg.
Present.
Thank you. We have a quorum.
Terrific. Thank you very much. And so at this stage, it's traditional for us to call for public comment on any matter that you'd like to address to the committee. Okay, seeing none, we'll then move to our first agenda item, which is approval of the minutes. Did we get the minutes?
Yeah, the minutes are now posted. They were just posted.
Oh, all right. Well, shall we take a minute to look at the minutes?
Yes.
All right, let's take a minute to look at the minutes.
And these are the minutes from the 18th of October, 17th of October CS Bars. The committee met 2 times in the month of October, working very hard. And that first October meeting was approved last time.
Is everybody able to access them? That's the first question. Sing out when you have them.
I still haven't been, I've only got the October 11th.
So it's linked on the agenda for today's CS Bars
Oh,
meeting.
it is.
Yeah, it just came up, just minutes ago.
Yeah, you might have to refresh.
You may have to refresh your screen. Brian, are you able to reach them? I'm
Yes.
happy to bring a copy of them.
Yes.
Natalie, do I need to have an account and password or?
No, I can set you up.
Okay.
So actually, once you click on it, you should be able to see.
Thank you.
You're welcome. You're always there.
So just taking a sense of the committee, if everybody's had a chance to review them sufficiently.
Yes, I have.
Yes.
And online, or on the phone, I should say? Bernice?
Yes.
Okay. Well, if everyone has had a chance, then I need a motion to approve them from somebody.
So move to approve
Okay.
minutes.
And a second?
Second.
Any further discussion?
Was Kareem at October 17th? Oh, wait. I didn't have.
Good question.
Just make
Greg was not, Greg was an observer. Should he abstain?
Anybody who was just an observer not participating should abstain, and we just need to make sure we have a quorum to approve.
Yeah, it was my plan to abstain from.
So Greg will abstain, and then, so Kareem is there, that's fine.
We have
Everybody
four,
else.
seven, so we have
Perfect.
Okay, we've got the procedural part straightened out here, because of course we have a new member, not able to vote on these particular minutes. And we do have a quorum for approval, so let's call the roll on this vote, shall we?
Sure. Pritikin,
Yes.
Frickberg,
Yes.
Ongora,
Aye.
Murphy,
I abstain, I was not present at the meeting.
Fertil,
Yes.
Brandis.
Aye.
Motion carries.
All right, that was more complicated than the minutes normally should be. But thank you, everybody, for your patience with that one. Let's go on then to our first further agenda, not our first agenda item, but our further agenda item, which is our staff report. Is that to you, Natalie?
Yes, I might, in respect of the time of Carolina, our guest, defer to that next item and continue with the staff report afterward, if that pleases the chair.
Okay, so the special set item, which is our data collection update, it appears there's also an attachment that's now showing under that item as well that wasn't present before. Am I
Yes,
right about that?
yes, and that attachment is the PowerPoint that will be shown to the group as a whole.
Okay,
It was sent in advance to our members on the phone, but it's made available to those on the webcast.
okay,
They should have readability issues.
okay. All right, so in that case, we'll just move to that agenda item. We'll defer the staff report and the recommendation on the moral character working group item as well. And we'll go right to you, Carolina, for this item at this time.
Do we need to pull it up?
Yeah. Carolina, would you like to join us up front?
Yeah, sure.
Okay.
File is fussy, so I'm going to pull up an alternate version of it. Thank you for your patience. I'd like to welcome Carolina Amarante from our Office of Research and Institutional.
I'd like to welcome Carolina Amarante from our Office of Research and Institutional Accountability, who's been assisting on this project, and we'll be talking about an update on the demographic metrics that will be collected starting in 2020 with the law schools. So Carolina, would you explain the strategic goal, and then I'll give the framework for the committee.
Sure. So as we discussed in prior presentations, much of this work is centered on this strategic goal 4, which looks at supporting access to legal services for low and moderate income Californians, and promote policies and programs to eliminate bias, and promote an inclusive environment in the legal system and for the public it serves, and strive to achieve a statewide attorney population that reflects the rich demographics of the state population. And this is part of much of the diversity, inclusion, access, and inclusion work that the State Bar has been moving forward on in the past year. And there are several objectives under this goal, and for the purpose of this presentation and the work that we're doing with the Cal Accredited Schools, we're looking at Objective G, which is work with the California Accredited Law Schools and Retro Schools to develop enhanced demographic reporting requirements for February 28, 2020. So much of this work that we're doing, again, is centered around this goal and this specific objective.
Thank you. And I'd also like to thank CS Bars for the input from this group that has shaped the proposal that we'll be sharing with you today. A number of the suggestions that you've provided have adjusted this proposal to be something that we think will be very achievable for the law schools. And we've also brought our counsel here to address some of the questions that were raised at the last meeting.
And to also provide some context again to the value of this data in enhancing the demographic categories in the annual report, we're looking to better understand enrollment, graduation, and attrition trends across different demographic groups, and looking at these populations across different law schools. So not only within the Cal Accredited and Retro schools, but also across the ABA. The timeline is, again, we're shooting for 2020, and we will be talking a little bit more about those different stages of rollout in this presentation. So many of you are familiar with this chart. This is part of the annual report that many of the schools provide data on. And much of the enhancements are focused solely on this chart. So this is section 21, ethnic and gender breakdown, where We currently receive information by different racial ethnic categories as well as their gender.
Are those the federal categories?
Those are not. So
And that's what I was wondering.
yeah.
Okay.
You're right on the ball there. That's what we're gonna be moving towards too. So the recommendations that we're moving towards too is going to be part of a 3-stage rollout. And again, we developed this rollout plan really in response to much of the questions and thinking and insights that were shared by many of you in prior presentations. And the first stage, we want to really align ourselves, as you mentioned, with the standard. And so the standard for ABA and iPads is not currently what we're collecting now. So for the first stage of enrollment, we're looking at obtaining race ethnicity for populations that are enrolled in law school as well as those that were granted a JD. So that's our first stage of rollout. And this will allow us to have an opportunity to develop that baseline data for looking at attrition, specifically with race ethnicity across all different law schools in California. The second stage, we would be expanding the gender categories. So ABA, iPads, their race ethnicity categories are similar. Those are aligned. ABA demographics are slightly different from iPads, where they do allow for a non-binary category. This is a standard and trend that's moving across all states and education systems. When looking at the work that iPads is doing regarding this area, I think they're still
has joined the conference.
Trying to adjust their policy, but have not done so yet. But schools have made this note to iPads regarding students wanting to identify other than male and female. So wanting to be aligned in best practices, we are proposing that the second stage of rollout, which should be fall 2021, would include not only the race and ethnicity categories of ABA and iPad categories, but more specifically, the binary, non-binary categories for gender that ABAs currently collect for their schools. Again, we would be expanding on the attrition baseline data, so we'll be looking at race, ethnicity, and gender across all California law schools. And then our third stage would be solely focused on JD awarded. So again, much of this work is us trying to understand the pathway into the profession, where there may be potential gaps, and how that experience varies across different demographic groups. So for the purpose of comparing the population to California licensees, we're focused on expanding the categories for JD awarded to include those veteran status, disability status, and sexual orientation. This would not be applied for all enrollment years, but more specifically to JD awarded, so we can have a baseline data to compare those that were awarded JD versus those that are California licensed attorneys, and seeing where the similarities and differences exist. So to provide a more clear visualization, again, the previous chart had different categories for race and ethnicity. They also had different categories for gender. So after the stage 2, these charts represent what the data would be, the type of data that would be shared after the first and second stage of rollout. And then for the third stage, these charts also visualize what the data would consist of when sharing with the State Bar, looking at those populations, heterosexual versus LGBTQIA+, decline unknown and total, similar, no disability reported, JD awarded, and then similarly veteran, not veteran status for JD awarded. So before I go to the next part, again, this is not going to be a all at once rollout period. We are looking to roll this out over the next few years to allow schools the opportunity to begin a process to collect that data. We also plan to send out a survey before the end of December to better understand what the data capacity of schools are, and that will then inform the structural materials that we would share to support this process. An additional point that came up in the conversation in our last CS Bar meeting was a question regarding privacy and confidentiality of student data reported to the State Bar. This time I'll turn that to Caroline.
Thanks, Carolina. So we looked into the committee's concerns raised regarding student privacy and reviewed various possibilities on our end in terms of safeguarding the data to address those concerns. And at our last meeting, one of the possibilities that was raised was a data sharing agreement between the State Bar and the Cal accredited law schools. The State Bar has since considered what that type of agreement with the Cal accredited law schools would look like, and ultimately decided that while it was appropriate with respect to data collection for our law school study with the ABA schools, it wouldn't really fit the circumstances here because the data at issue is going to need to be retained on an ongoing basis for regulatory purposes and for monitoring purposes. So it's not really going to look quite the same as that other data that we collected. We also looked closely at the Sander litigation and decisions from the court during that litigation and the statutory requirement that applicant data be kept confidential by the State Bar, and that's contained in Business and Professions Code 6060.25. It's important to keep in mind that the statutory prohibition on disclosure of confidential applicant data only applies against the State Bar. It doesn't apply against the law schools with respect to student data. And also important to note is that in the Sander Supreme Court decision, while disclosure of de-identified data didn't necessarily implicate an applicant's privacy rights, identifying information obtained with a promise of confidentiality is not subject to the right of public access when the public interest would be furthered by maintaining confidentiality. So the State Bar takes that to mean that data received from the law schools pursuant to our regulatory mission is sort of obtained with the purpose of, or with the intent of confidentiality, and you know, we will maintain that data in the strictest of confidence and use it only for the regulatory purposes essentially communicated today. And it's also the State Bar's position that identifying information submitted by the law schools for this purpose is not going to be subject to disclosure under the CPRA or related public access laws, and we will protect that data, you know, asserting that position with the full effect of the law. And so for these reasons, we've decided that, or concluded that the requisite safeguards are already in place for us to move forward with this enhanced demographic data collection effort. We think it's really important for the reasons that are outlined in here, in particular, bringing us up to date and up to sort of get up to speed with the federal standards. And we'll continue to work with the Cal accredited law schools to resolve any issues about privacy as they arise, and we know this is going to be a process. It's, as Carolina said, a multi-year rollout plan, so you know, we anticipate that other questions will come up, and we'll do our best to address those questions.
Yes, go ahead, Craig.
Just a question on the data. I gather that all the reporting on the categories are by individuals self-identifying. Okay. All right. Have there been any studies on whether that produces some anomalies? I'm just curious. I don't know the answer.
We looked into this process closely because the State Bar also is responsible for disseminating an attorney census survey, where attorneys are asked to self-report their race, ethnicity, their gender, their sexual orientation, disability, and now veteran status. And we looked at the practice that Census has came across. We also looked at just best practices for providing or obtaining demographic data. And so self-reporting is the best approach for obtaining that data, as well as not restricting individuals into specific categories, allowing individuals to select all when possible, actually allows for a more accurate picture of the population.
I have a question, Ms. Holmes. I just want to make sure I'm understanding. That was a pretty quick report when I was trying to take notes, but so the State Bar has concluded that sufficient safeguards are in place such that the state bar's intent to keep information provided by the schools confidential and not subject to disclosure should be enough that people would not be able to get at this information, at least from the state bar. Is that your opinion?
So we've concluded that we have the requisite safeguards in place on our end to maintain that information and receive it in confidence. And, you know, having reviewed really closely the court decisions that sort of deal with applicant privacy issues, we think that this data falls under the category of implicating privacy rights, assuming that it falls under the 11 threshold, that it implicates privacy rights and that it can be maintained in confidence. So we don't have, in terms of our receipt of the data and our maintenance of the data for regulatory purposes, we think we're in a strong position to keep that data in confidence.
And that analysis applies to the state bar, but not to the actual schools, correct?
In terms of
whether the schools can prevent disclosure or someone seeking to disclose that information.
Well, so the schools are going to be subject to different laws and regulations regarding collection and receipt of information. We can't really speak to, I mean, you know, we're looking at it from the perspective of what can the state bar receive and maintain. So the schools may wish to, you know, look at their collection efforts.
Right, let me just jump in here and ask, let's complete the staff presentation if we haven't, and then we'll have more committee discussion on this question. I'd like to be sure we've taken public comment on this specific issue after the staff presentation, before the committee has its conversations, if that's all right. So I don't mean to cut it off, we'll get back to your question.
Yes, you did, but that's perfectly fine.
All right,
And
we'll
Greg,
get back to your question, but let's be sure we've done it in the right order so that, yes.
Could I make a quick comment before we return to the presentation for the benefit of our newest member, Greg Murphy? So just a couple of quick comments. A lot of the council points of view are focused on the California Public Records Act, which is an additional layer to which the state bar is subject, whereas the schools.
I'm familiar with it because it raised issues, so you don't have to worry.
Great. And then over the years, for many years, the schools have been reporting demographic data by year, but curiously we've never requested the JD awarded previously. And so this would be, in the first year, adding 3 additional demographic categories in addition to those that have been collected over the years without an issue for a long time.
All right, so let's go back and finish our staff presentation.
All right, sounds good. So this is the final key points that we want to communicate. So we're very interested in understanding how to best provide instructions to make this a successful process. So the State Bar will send out a survey to capture information on the various data collection practices that schools utilize to obtain this type of information, and then use that information to then develop helpful instructional materials that can best support that process moving forward. And again, really trying to incorporate best practices that we have learned for collecting demographic data in this type of nature. And then, you know, we are targeting much of these efforts to roll out in spring 2020 in support of the first stage rollout in the fall of 2020. And we will plan to collect, analyze the data, and report on the aggregate counts by school type to CS bars and CBE on an annual basis. So this data, we won't be keeping it to ourselves. We really want to make it available to everyone so we can have the necessary discussions to see where there's opportunity for additional review, as well as where best practices can be considered for supporting, again, underrepresented populations in law schools. So those are the next steps.
Mm-hmm. And part of that timing was developed based on informal conversations with the schools that came forward to be sort of test cases, and many of them, but not all, indicated that they were likely to collect this information at the start of the school year in orientation with their largest classes starting in the fall. That's not appropriate for every school. We know that some have multiple or different starts, but that's the most common, and so we aimed for that common denominator.
That's it? Okay, all right. Well, let me be sure that we have an opportunity for public comment on this. Let me begin with anybody who's on the phone. Any members of the public on the phone who want to comment on this particular item, just this item? All right, sounds like none. Any members of the public in the room who would like to comment on this particular item? Seeing none, we'll turn it back to the committee. And again, let me, in deference to our members who are on the phone, start with you. If you have comments or questions about this particular item, let's begin there. Dean Pritikin or Dean Frickberg?
None at this time.
All right, back to the room. Back to you, Brian.
Okay.
I interrupted you before. You should have first priority when we come back.
My intended question at that point was, if I'm understanding that the state bar is convinced that its receipt of this information is protected by various safeguards, case law, statutes, I'm more concerned about the sending of that information by the schools and the disclosure by the school to the state bar, and whether there are specific safeguards in place for the schools having done that. And I'm hate to say I have not researched that, but I'm wondering if you came across that in yours.
So I was really looking at it from our perspective of the state bar's receipt of information, because we aren't in a position to sort of regulate how the information is collected and how the schools navigate the general reporting requirements with their students. I don't know that the state bar is really in the best position to evaluate those questions, because they don't really pertain to our legal obligations with respect to receipt of the data. But, you know, I think in terms of the concerns that were raised at the last meeting, my understanding was that the concern was about whether or not the state bar would be required to disclose the information in response to requests, which is why I was looking at it, you know, through that lens.
Well, I mean, I think some of the concerns, and I don't want to speak for other people, some who aren't here, but some of the concerns were whether the schools are really in the best position to collect this data, and especially how can we keep it confidential if we have such a small student body that just creating this chart tells you exactly who that student is, rather than keeping it confidential. And so those are some of the issues that I think are still out there. I'm concerned that if the state bar has enough safeguards in place and the state bar registers our students, it's still my position that the state bar ought to collect the data. So I'll make comments with that.
And I'll put out there as a coming attraction in a future item in the staff report, we'll be talking about some steps that we're taking to evaluate whether that could take place in the future.
Thank you.
And another item I just want to respond to is the concern about the data, the incoming data. We're in that predicament now with the data that we're collecting. And I think our big safeguard has been that we don't report anything under 11, a cell count of 11. But this dilemma, it wouldn't be new. I mean, we have that scenario now. I mean, I think if anything, we are changing, morphing, and modifying the categories. But in terms of a data collection that could potentially identify or be required from the school's perspective, this has been our predicament at the moment. So I think that in terms of, it wouldn't be a new dilemma for the schools. I mean, we haven't had that issue so far.
I'm just repeating what I've heard in the last several meetings when we've discussed this, but are you saying that if a school doesn't have at least 11 people in a category, then they don't have to report them?
No, I guess what I'm saying is, it sounds like the concern is that schools would be providing information where a student's anonymity could be disclosed, or the data might be, you might be required to disclose that data at some point. We're still in that dilemma whether or not we change or modify any of these variables, because I think one of the first screens that we saw was the data that we're currently collecting. If any, it's pretty much the same data. We're modifying it to meet and to match ABA and IPED's data collection formats. But the action itself of schools collecting the data and presenting it to us, regardless of whether that has 11 or more cell counts, is something that exists now. And I'm just curious whether schools have thought about the current process. It's not a new dilemma.
It's just that our school particularly doesn't collect this kind of demographic information. We have very few categories, if any, on our application process. We don't. Now we're going to have to expand it quite a bit. And that was one of the concerns, was not just doing that and whether 11 or more need to be existing in a category, but the idea that will students actually come forward giving it to a smaller school's registrar, knowing that it's not confidential to the school. That person will lose anonymity most likely, aside from the issue of sending it on to the state bar. And I thought that the conversation that I've heard included comments like, well, a student's more likely to think it's anonymous if you give it to the state bar. It's a much bigger institution. They have to register anyway. You're more likely to get accurate information if that's where they report it, rather than to the registrar they see every day when they come in and say hi, and how the kids. I mean, that's kind of our school. And I'm sure I'm not alone.
So Brian, right now at Empire, you are reporting this information in almost all of these categories, just the addition of a couple more. Has there been pushback from students so far?
Not that I know of from my school. No. This is a combination of different conversations I've heard and discussions in our meetings over the last year that I've attended. It's not just from our perspective.
Right?
Forgive my ignorance, but do the CBAR schools receive federal funds through Title IV? Some of them do, maybe.
Some of us do, yes.
So has any analysis been done whether this complies with FERPA?
I don't know.
The CS BARS schools, if they do have that, it would be through a partner accreditation such as WASC, rather than the granting of the CAL accreditation.
Yeah, you're asking for disclosure of information related to students, some of which may in fact be individual identifiable, and I'm only asking, has anyone looked at the question of whether schools reporting this to the State Bar of California complies with FERPA? I don't know the answer, but it should be.
So Greg, let me just trace this. This issue's been the subject of agenda items 2 or 3 times anyway, certainly since, and in those conversations, the schools have repeatedly raised FERPA concerns about this process. So there are definitely members of our school community very concerned about FERPA implications of this. Most of the schools make every effort to comply with FERPA, even if it doesn't directly apply, because as you probably know, students expect it to apply, even though it actually doesn't. So most of the schools try to comply with that regardless of whether they meet the threshold for it.
And is it a condition of accreditation that schools agree to provide this kind of information?
Well, so let's just be clear about the conversation. It's absolutely true that the schools have been providing this data, for a long time. There's no question about it. And in fact, I think it's a very valid point to say, have you had problems with this data before? And the reality is, I don't imagine that many of our schools have. But the categories are changing. And the categories are now touching on things that are much different and potentially a lot more explosive for some populations. So that's the big difference between what's happening today and tomorrow. People are accustomed, I think, to being asked about gender and ethnicity. So actually the first stage rollout, I'll just give my opinion on this at this stage. The first stage rollout where we match the IPEDS categories, I don't think that's terribly controversial. I think it gets to be a lot more controversial when we start asking about sexual orientation and gender identity and some of the enhanced categories, like enhanced interrogation categories, that come along later in this plan. And I think that's where the schools have very significant and legitimate concerns. So particularly in respect to privacy and FERPA and our obligation not to call out a particular individual for their sexual orientation or their gender identity or whatever it is. And that will in fact happen with this enhanced sweep of categories. There will be many occasions where there's one person there. So, I mean,
That's, I noticed that there was a category for not, I'm just curious, is it required as a condition of accreditation by this body or with this body that it report this kind of data? Because you're putting additional responsibilities and duties on the schools, and I'm just curious if the school said,
right,
we're not gonna do that, then they stand the risk of losing accreditation.
there is neither a rule nor a guideline on this reporting, to my knowledge.
If I could comment real quickly, from my understanding of the community bar examiner has been undergoing kind of a shift and a transformation over the past year. That was addressed by the Columbus Supreme Court, that's been sending forth some mandates. So a part of the greater theme and the greater cause is that we're trying to collect data to be more informed when we're making our decisions and what is actually going to help increase access to justice, as well as assist students attending these opportunity schools and getting resources or additional access. So while there is no rule and there is no mandate, it's a part of a culture change that I'm seeing at the committee level. So.
With that said, the students retain the right to decline to state.
I want to make it clear, by asking questions, I'm not stating a position one way or the other. I'm just thinking of the potential issues, and if the school said, you know, it's our philosophy, we just don't collect that because we don't want to. And it's possible there's a school out there, what would happen in terms of its accreditation?
So it's obvious, you can see what my position is on this. I've raised this repeatedly in meetings. We have to address all these concerns. So I'm going to make a formal request for a written version of the opinion you just gave us, Caroline. That is written, an opinion of council that is made public by the state bar respecting the state bar's position on protecting this data. And I think that would be a very good way to advance the conversations around these enhanced categories of data collection. There are occasions when opinions of council have been made public in the past by the state bar, and I think that would assist all of us in really understanding formally what that looks like in terms of its the state bar's efforts to protect this data.
So just so I'm understanding, because I think there were two questions going on. So today, you know, I've addressed the state bar's position in terms of receipt of the data. But then I'm also hearing from Brian that the real concern is about collection of the data on the part of the schools. The collection of the data piece, I think, is something that the schools need to address when they're discussing what process they're going to implement to collect this data, because every school is going to be subject to different statutes, different laws. Some are going to be subject to FERPA, possibly, some aren't. So that's not really something that the state bar can mediate.
And I wasn't asking
Right.
you to give an opinion on that.
So I just want to make sure that I'm understanding. So are there still, you're saying that the concerns are still existing as to our receipt of the data and the existing safeguards in place for withstanding a Public Records Act request for the data?
Yes, and that's the reason that I believe that a written opinion would be emollient to all the school's concerns. It would also be the basis for any challenges that our students might choose to bring. They would bring them to us, we would hand them the written opinion of the state bar in respect to how the state bar will protect the data, and hopefully that would be the end of it. And that would be a very useful thing, I think, for the students who might object to us asking them these questions, which we're now going to have to do. We're going to have to conduct some kind of survey or in some fashion collect that information from them.
I guess I'm also not clear on how the option to decline to state doesn't address that concern.
Well, I see it, the way I see it, we have got to put a very prominent disclosure on our survey that says this data will be furnished to the state bar and you may be personally identifiable as a result of your decision to check certain boxes in connection with this survey. And know that that's what's going to happen when you answer. Because we can't not do that.
Does that happen now?
Yeah, does that disclosure
It
exist?
does not happen now, and it probably should.
And just a clarification, when they identify, the actual data that the schools will report will not be specifically identified, so we will not be receiving any student names.
Yeah, Yeah, but again, if you have one person in the category of LGBT Pacific Islander in your school, you've identified that individual.
So
And there won't be that many, you know, in some of these schools there are 45, 50 people all together in the school. You add more categories, that spreads them out more. You then matrix it with all these other characterizations, and it becomes completely personally identifiable information that we're furnishing.
So if I could just clarify, we were very cautious about how we want to get the aggregate data that we're collecting. So the intersectional analysis that you're referring to would really be limited to gender and race ethnicity. We're not going to apply that same analysis to sexual orientation, veteran status, and disability. So if you have one person who's LGBTQ in your school, you know, that's a decision that you have to make. Well, it's also a decision that student whether they want to communicate that to anyone. And so, again, we were just very careful about understanding that these populations can be smaller. And so we're not requesting intersection analysis for the expanded categories for JD population.
All right, so let me just go back for a second because I want to refer to the specific way you described it and be sure that we're on the same page and understanding this. Report student enrollment in JD awarded using ABA demographics for gender. That's binary and non-binary gender. That's stage 2, fall of 2021. So I envision you adding to that chart, that detailed level of data, a first-year female, non-binary gender category person. That's a matrix analysis on that character right there. That will personally identify that individual in a small population. Am I wrong about that?
So you are correct that just to note, the standard right now, and again, we looked at this very closely. We looked at IPED's practices. We spoke with the ABA. I also reviewed several responses and research articles that have gone to Department of Education. Not allowing individuals to identify a non-binary, to allowing them to not, we're essentially not collecting accurate data. That's the challenge we're with.
I understand I do really understand where you're coming from on that. From our standpoint, that needs to be disclosed. And I would recommend to any school I was talking to a big red flashing disclosure on the top of that survey that this information will personally identify your gender to the state bar. And we should be doing that now. The reality is we should all be doing that now.
So I guess where I'm a little bit confused, and again, we want to have input from the schools, that's why we're doing the survey.
Yeah.
Is if we're, and again, I apologize if this was already answered, if the state bar is not receiving the name and identity of the school, how would they be personally identified by the state bar?
So the state bar will ultimately have the registration for those people, right? And originally, when this proposal first came along, you did want to be able to track by individual retention rates, right?
So we no longer plan to do that.
So let's talk about that part of it. There's no plan for the state bar to be able to match up on an individual basis. Let me be sure we understand that correctly then. So we're not reporting rates or percentages on graduation. You're not tying them back to these categories. When we report a JD awarded in category, whatever category of race or ethnicity or gender or ultimately sexual orientation and all the rest of that, JD awarded, you're not in somehow tracking that back to the reporting we gave along the way in any fashion?
So we want to be just cautious about what we mean by tracking.
Yeah.
There's identification on individuals over each stage of their enrollment that schools would be best positioned to do because they have that identifying information and they can see at what point that student, based on their race, ethnicity, their gender, what have you, is no longer involved in the school. We won't have that level of data. We're looking at aggregate counts to see where there are trends, to share it with schools in order so that we can have a conversation similar to what was mentioned before, how we can support those populations that are underrepresented.
But what we certainly did with the data that we have from the ABA schools, for example, we said, okay, this is how many people were graduated in the various categories in X year. ABA school, assume it's a 3-year school, so we look at how many people were enrolled 3 years earlier. So for the CALs, the registered schools, we might say, you assume a 4-year enrollment to graduation period. So you're looking at the report potentially from 4 years ago and looking at the report from today to see what the attrition rate is. So you can see, as we saw with the ABAs when we looked at the data, that there was a big disparity in the attrition rate between whites and non-whites. That all that's doing is taking those 2 separate reports and looking at the enrollment from 1 year and the JD awarding from the other to see what the attrition is roughly. It's not a perfect match because not everyone is graduating in 4 years, but it gives you a decent sense of what the attrition rate looks like. So I wanted to be clear that that is something that we would very much want to do with the data.
And recognizing that in some of those categories, there's one person. By the time you matrix it all through, there's one person that started 4 years ago and either does or does not graduate later on. One identifiable person who registered with the state bar and they're in their first year of law school. So the state bar has the data to personally identify that individual.
But for the purposes of our analysis, we would be looking on an aggregate level.
And we should probably put that down in some fashion so that it's very clear and we can state to our students when they're answering these surveys, here's the disclosures you should have as you're answering. This is what the state bar will do with the information that you're being provided. Otherwise, you've raised this countless times. Why don't you just collect it and then we're not in this position? But if you want us to collect it, then we've got to address these issues for the populations that we're dealing with.
I don't think it'll be hard to add, how the data will be used. If we also want to create that script for the schools as part of the data collection tool. But I think Natalie hinted on this earlier, but our current system, when students register, these demographic variables are already being collected. And so eventually, maybe if we could morph this into, as part of our data collection process. What we're unable to assess at the moment is whether we have the accurate census. Students are required to apply within the first 90 days as registering as law students, and we have no way of detecting whether we have the full census. That is, whether everybody meets that obligation, and so, or that requirement. So for the moment, we're going to rely on the schools collecting this information. We could supply that disclosure in terms of how we're collecting the data and how it will be applied and the data limitations, and leave it at that.
And can we get an opinion of council on how the state bar will protect the information?
So I wanted to speak to, the state bar isn't in a position to draft a disclosure statement for the schools because all of the schools are going to be subject to different laws and regulations, and we can't provide legal advice to the schools. So we can't do that. But we could provide maybe some additional clarity about how the data is maintained that would allow the schools to craft their own disclosure language that they feel would put the students sufficiently on notice about how the data is being collected and all these and maintained and received by the state bar. In terms of providing an opinion, providing a written opinion from the state bar, we can write down it's our position that this data is being collected in confidence for regulatory purposes, and that we will, to the extent that it's requested in a CPRA request, we're going to take that position and we're going to put the full force of our, legal team and defense behind it. But that opinion isn't going to have a legal effect. So I'm reluctant to draft an opinion like that when it doesn't actually have the effect that I think that we're hoping that it would. But I do think we can maybe provide some of that additional clarity about how the data is maintained so that you are giving your students the opportunity to opt out if they're really uncomfortable with it. And I think that that's the decline to state option. And so
with full and appropriate information, that's what I'm concerned about. I want the student to have the information about what the State Bar plans to do with the data, but also how the State Bar is committed to protecting their privacy. That's where the opinion of counsel, which is, all I'm asking for is what you told us in the meeting, in writing. That's all I want. We've analyzed these various sources. We believe, based on our analysis, that this is the appropriate treatment of the data. Here's how it relates to the Public Records Act. Here's how it relates to the various self-disclosure things. This is what the State Bar will do in the event of a request for your data. And that I want to be able to give to our students, along with a disclosure about how it's going to be retained and used for analysis, which is a different thing. That's not council opinion. That's the opinion, that's the State Bar's position on how it uses the data. If I have those two things to give to students when they're answering the survey, then I think I've fulfilled a reasonable disclosure obligation for them when it comes to data that some of them may consider extremely sensitive. People are used to certain categories. We're collecting enhanced data. I think they deserve to understand how it will be retained and used and what the State Bar will do to defend their data in writing.
And potentially, as we go forward, I think something that could help the process, that could be helpful to students and the schools as well, is to provide something, not only this, but something more than a sanitized statement, because we believe that many students will actually be very supportive of this project, and that the schools, in some sense, will as well. You will have a way to demonstrate a commitment that you know that you have as Opportunity Schools and that you fulfill. This will be the data to back it up. And we can talk a little bit more about the mission, and in so creating the disclosure, also share some of the things that we find that can demonstrate the success and the value of the schools, but also can help small populations who choose to identify to be seen and to feel included.
So
In a way that's important.
you're exactly right. I've been approaching this as a lawyer, not as a dean, I guess. So fair enough, fair point. Yeah.
And those are things that we could do to help in that process so that it doesn't seem like a black box. It's not intended to be a mystery. It's intended to support the mission of the schools and students, and it's perfectly reasonable for us to show how.
Great.
I'd just like to return briefly to the question of whether the schools were required to participate in the survey or it's voluntary. And that goes to, and you understand your regulatory scheme better than I know that the Supreme Court went through restructuring not too terribly long ago, but you're asking schools to adopt additional burdens of gathering this information and reporting. I know they're reporting some of it already, but additional information, that cost, there's a cost associated with that. And these are hot button issues politically too in our society. So my question is the school's accreditation, again, is this a matter of accreditation or not? I mean, could a school say, thanks, but no thanks, you can collect it yourself?
Well, we're in a transition period. I mean, so there is a reporting requirement right now from the schools. However,
It goes by Supreme Court or?
As part of the accreditation process, so it's a State Bar rule as well as, don't we have isn't there a PMP code that is related to this data collection requirement? So we're also in a transition right now.
I'm not arguing against it. Is it required or not? And
Yeah,
could
it
schools
is.
say no?
It is, but we're also in a transition.
And if it said no, could it thereby risk its accreditation?
Right. Well, let me just say that we're also in a transition period where we're reevaluating, we're going to get to that in a minute, and tie rules to values. For example, one of the values that we've discussed here numerous times is the value of diversity in the school population.
I don't want to argue policy.
Oh,
I just want to say, what is the current rule?
Well, the current
Because I think you should be clear on that.
is-
And then I think if I were dean of the school, I'd want to ask, is this compliant with FERPA if I get Title IV funds? That's all. I'm not arguing the policy, whether it's a good idea to collect it or not. I'm just saying, what are the current rules?
And
And do they need to be changed if you want to require it?
And so I'm not, sorry, let me just say this, I'm not arguing it either, I just wanted to let you know that, where the state of affairs is in our data collection. So our data collection, it is a requirement. Now, but we're also in a transition period, which is what we're gonna get to in a minute, and that is, we want our values and values that we find in accreditation, we're gonna operationalize those and look at, for example, if we value diversity, how do we measure input and regulate that in the system? And part of that will be data collection. So inevitably, some of this is going to be required. We can't say that we want to, put forth diversity in our accreditation or as part of an accreditation value without being able to measure that. So, and we can do that because reporting is one of the requirements. So I just want to put that out there. That is a schematic that we're in right now.
Yeah, I get your point. My point is when you add additional burdens on schools, that has an effect on the value of affordability, right? Yeah. And, you know, there's mission creep that occurs here, and who's going to ultimately bear that burden? The State Bar, California society, or the individual schools, which means the students. And I think you need to weigh all those things as you're going through this process. Everybody loves data. Yeah. I mean, data is great, but there's a cost to obtaining it.
Well, and that, Carolina, I don't know if you've gotten to the part where we're talking about the survey of school data collection capacity. So we can, so that's one of the things that we want to do is understand what the data collection capacities of the various schools are that would, and what kind of impact these additional requirements would have. And so and that will help us figure out sort of how to give them individual instruction on how to translate the information they currently collect into the information that we are looking for, what additional requirements there would be. I think there's an assumption that there is a significant cost for the additional data collection that may be true for some schools and may not be true for a lot of other schools. And so, so that's certainly something that that assessment of the capacity, which Carolina, I think you were planning on launching that survey before the end of the calendar year. Before the end of this calendar year, so this month.
That's correct. And again, we are looking at understanding, you know, what the current process is, and having experience in doing this work in other institutional settings. I'm aware that certain jurisdictions, or certain agencies, or rather schools, may have a set team that does this, or it might be one person. There might be a database already set up to do that, and that database is maintained internally by the IT department, in which modifications to a dropdown can be done easily. Or this is something that might be part of a outsourced contract with a vendor, and that might require additional conversation. Schools may be, you know, wanting to have a reason to update their system and may use this as an opportunity to push for more funding within their jurisdiction. So again, we want to try to understand the various circumstances these schools are, so that we can then respond accordingly with the support and materials that can speak to where they are in their data collection process.
And then finally, as Amy mentioned, and Greg, as you've alluded to, we are now collecting those same categories of information as part of our registration. And that is new. We didn't used to collect as broad categories, but so that is new. So certainly one of the things that we can do, as Amy mentioned, we haven't looked back to see whether the number of people who register at a given time matches your numbers. Certainly that's something that we should be able to do, right? You are reporting to us total enrollment in a given year. So the next year I should be able to look at my data of all the registered law students and see if that adds up, I'm guessing. So that's something that we can certainly do to give us some greater insight into how much of that information we are capturing. And I think that you know, we're going to sort of, not to jump ahead into the discussion for later today, but to the extent that, you know, we determine that one of the values, one of the purposes of the State Bar accrediting California law schools is because we want there to be, we want law schools, we accredit law schools for the purpose of Natalie's got this written down really well, of ensuring that we, recruit and maintain and graduate law students from diverse backgrounds. There's some obligation on the schools to meet that requirement, and so the State Bar, may or may not be in the position to pull all of the data to support that, but that may be one of our principles of why we accredit law schools, is to make sure that we provide those opportunities for students of diverse backgrounds. So to the extent that we can partner in figuring out sort of the best way to get that data, obviously that's what we are trying to do.
Yeah, and let me say that, some of I came out of the box a little strongly on some of this. I'm trying to present the views of our schools, not necessarily just Greg Brandis'. There's a very deep level of concern in some category, some quarters about the way we're going about this. So, I'm entirely a data wonk personally as well. So I know there's a lot you can learn from the information. We just have to work through these various issues effectively. And along that line, I want to say how much I appreciate what has evolved here today's presentation. It probably doesn't seem that way, but I do very much appreciate the thoughtful work that has been done on today's variation of it and the timeline and other things to address the concerns that have been raised. So I should have said that at the beginning as opposed to after all that other stuff. So let me turn back to our colleagues who are on the phone, because there's been a lively back and forth here in the room, and probably you haven't had a chance to get a word in edgewise. Dean Pritikin or Dean Friedberg?
I actually don't have anything to add on this. Thank you, though.
Okay.
And I think all the points that I addressed in our last meeting were already readdressed today, so I don't have anything additional to add right now.
All right. Well, let me just sum up a second. I'm still requesting that we get a written opinion from the State Bar on the State Bar's legal stance, what it will do when there's a request for this data. I've been around the State Bar a long time, and I know that things change over time. So it's great to have an opinion of counsel that we can point to as an official long-term position that we can hand out to folks. Second, we have the disclosure work that in some fashion, we should come to a set of disclosures from the bar about what they're going to do with the data. In other words, just something we can attach to it when we ask for these questions. And I think those two things will make a very great difference in terms of our ability to understand exactly what we have to tell students about this process, so they can choose with good data whether they want to answer those questions or not answer those questions.
And just quickly to respond, so we will look into what the State Bar can provide, and to the extent that we're cautious about providing a written opinion, it's really more because we can't provide legal advice to the individual schools for all the reasons.
That's not what I'm requesting.
Right, but it also, we also have to avoid guaranteeing a particular outcome or doing, there's a lot of ways in which that won't necessarily serve all parties involved, because the word of the State Bar is not, the word of the court. So we'll look into what possibilities might be out there to try to address that and circle back about it.
Okay.
Well, I'm sure a complete defense and indemnity agreement would be acceptable.
I know that's what everybody wants, right?
That would be another way to go about it.
No, but that helps clarify sort of what all of the various concerns about privacy are. I know it's not just one thing or the other. There's many of them. I know. But so, anyways, that's the hesitancy, and that's what we'll look at, how we can do that without sort of running afoul of those, issues.
Sure, absolutely. Mm-hmm. And we do understand that the State Bar can't give us legal advice. They can't even advise the students. We can just pass along what the bar has committed to do, and these are both flavors of the same thing. Mm-hmm. What we're going to do with the data, how it will be stored, how it will be used. We will never report data this way, whatever it is, whatever we were able to say about that. And the same thing here. In the event of a public records request, we will take the following position. We will not necessarily win, but we will take that position. And that's a great assurance, of course, to students that the bar has committed to protect that data. So, and, you know, obviously statutes change and all those things happen over time, and we have to be responsive to that with the students and with their understandings. Because believe it or not, we're training baby lawyers here, and they go root around and dig this stuff and they throw it in our face. All the time. Every single right they have, they find a way to bring that forward to us in some fashion in the operation of the schools. So. All right, well, have we exhausted our...
If you bring that to us though, Greg, you must also bring the thank you notes from the students who appreciate the analysis.
To your point, right, exactly. Some students will want to see that data, there's no question about it. All right, well, I've certainly exhausted myself on this. Has everybody exhausted themselves on this one? All right, Carolina, thank you very much. I appreciate it. Everyone else on that particular one. Does that bring us to, yes, it brings us almost to the noon hour. Are we, do we want to break? Is lunch there? Should we break for lunch at this point? What's your recommendation?
Lunch will be here in a few moments. We can do so, but I might suggest that we use this time to look at the first two items on the staff report, which actually relate to this discussion.
Okay,
It's fresh in
terrific.
people's mind.
So we'll go back to the staff report and turn it over to the staff.
Thank you. I feel like I paid Dean Bertil to tee up item 1 of the staff report, which is a discussion of the admissions certifications for schools with multiple start dates. One of those things that the schools have asked is why is the State Bar not collecting demographic data? Really there are a number of reasons at this moment. Might it be possible in the future? We don't know the answer to that. But here's a first step that could relate to that process, but is also helpful for a number of reasons. We have collected the admissions certifications over the years, but we have noticed two things more recently. Those admission certifications can be matched internally to the student registrations, to Donna's point, to figure out how fully the students are registering. And so that's a first proof of concept as to whether or not students will come to the State Bar to do this. Because getting that demographic data, especially getting it year by year, requires not only the current procedure, but also normally students register at the beginning of their career, and then we don't hear from them again until they register for the first year, if they're at a registered school, or they register for the bar exam otherwise. And so now we'd be asking them to come forth 1, 2, 3, 4 times. But we are not sure the extent to which they're coming forth on that first time. And I started to look at why, and I discovered a couple of things. The first thing is that many schools have multiple starts. So most ABA-approved schools have 1 or 2 starts. Most start around September. A few also start
Has left the conference.
around January as well. But there's much greater flexibility in both the registered and the accredited schools, and some are not sure how to report it. And so we need information about when the schools are doing their starts. So that's one thing. And then the second thing is, once we understand the compliance, we would like to ask for help from the schools to figure out how to incent students to apply. In the past, there was a late fee that applied to students who did not register. That late fee was removed primarily to assist students from out of state. So a student who is going to law school in Iowa, somewhere along the line, spouse gets a job in California, they decide in their 3rd year that they're going to take the California bar. They then register with California and are subject to a late fee. It doesn't really affect our schools, all of whom should register right at the beginning. And one idea that we bandied about in preparing for this meeting is the possibility of having students show evidence to the school before registering for classes or before registering for future years. And we can talk more about this. This is really just to introduce the concept, but I'd be interested in sort of immediate feedback from schools. What concerns or what support would you have for requiring the registration as one of your administrative requirements?
All right, let's go to our colleagues on the phone. comments or concerns, Deans Frickberg and Pritikin?
I would always, Jay Frickberg, I'd always be very supportive of having us required to register them. It's been a perennial problem at UWLA and I'm sure at other schools. And again, the difficulty has been getting feedback from the bar on which students have or have not registered.
And curiously, we believe that for privacy reasons, we cannot report back to you those that are registered. We would probably have to do the internal comparison. So to Dean Brandis' point, we do carefully protect the privacy of the students to the extent that we can.
Dean Pritikin, anything else? Anything on this?
Nope, thank you.
Okay. To members in the room?
Well, I don't mind inquiring at it, but if the state bar can't tell us that it's happened, how do we confirm that the student has done what they said they did?
They could, for example, show their status screen. They could give a screen print of their status screen that they have registered when they register with Ames.
Okay, so we have to require them to do this and then also check back in with us once they've done it and prove to us they've done it before they start some other component of their education.
And we don't know whether this is a good course of action or not. It's something that we are proposing in part in support of the school's requests to evaluate whether or not the state bar could eventually collect this data. So that's one idea, and we're open to others. A number of years ago at the registrar's meeting, they talked about more winsome ways, including raffles or prizes for students who registered on time. And there might be still other ideas that are effective.
We would do that now to get them to come to class. I'm kidding there, I am kidding there, sorry.
For the record.
Yes.
Krim, you look like you were drawing a breath. Say something?
Well, it's funny that you say that because it's kind of the world that I come from, right? Where it's the more positive behavior intervention strategies and how do you promote and encourage it as opposed to penalize and focus on that element of it. But was that kind of like in jest, or is that something really that you're exploring?
Oh, no, the state bar is not exploring that,
Okay.
but it's something that registrars raised as something that they might consider at some point. I don't know that a school actually did so. I don't believe the state bar will be entering that.
Yeah, it'd be interesting to look at from a localized level how that looks, or if there are any activities of that sort, considering that we have a new generation coming in to the fold, attending law schools. It is now a Generation Z coming in, and even though I'm a millennial, Generation Zs communicate differently than I would, or people from other generations will. So I come from a communications background, so that's always very interesting to me when these conversations arise. But thank you.
Well, you see, it'd be very, very straightforward. So you could have a system of badges that they collect. Each year they update their profile in Ames. They collect another badge. And then when they get to applying to take the bar exam, they turn in their badges for a discount on the registration on the bar exam. And you have an incentive system right there. It's very simple. It addresses the sort of Gen Z. We gamify it so that the students really want to come and update their profile every chance they get.
And it shall be funded by a slight increase in the annual fee.
Okay, so we want to talk about that? So all of these ideas, again, are things you want the school to do. So we now have the proposals, we set up a whole program where you have to collect their evidence, verify it against their registration, block them from attending class if they don't complete the task and prove it to us. So I mean, again, that's happy to put it onto the school to do all of that work. So do we get a reduction in our annual registration if we take on that responsibility? Because when we want you to do something, you want to raise the fees on us. How about we talk about it the other way around?
Well, part of what I'm raising is that it's attractive, the idea that the state bar will collect it directly, and the state bar is open to addressing that. But in fact, it might actually add another layer of data. We don't know unless we can come up with a more creative idea. And so what I mean to lay out now really is the following. we'll be reaching out to the schools to make sure we better understand what your starts are, especially as the schools pursue more online options that might offer more flexibility. And we will be doing that in part for overall regulatory understanding, but in part to see whether this type of information could reasonably be collected more efficiently by the State Bar or not. And this could be one of the reasons why it might not be barring a superior idea that we may develop together.
So more to come sort of on whether you can analyze, based on admission certifications, the level of compliance you already have. We're working on that, right? That's a valuable thing, obviously. Since you can't tell us, we can't follow up one by one. So let's continue the conversation about other ways we could work together to bring this about. The schools fully support the registration requirement, right? It's, it's always a tug of war between who's doing what and how much there is to do.
And I believe this will be an ongoing dialogue because we've already started some of that data validation. If you consider how we've handled NPR for the past year, we validate each of those numbers that go in, applicants. And so I think we follow a similar format. And so we definitely are building our analytic capacity internally with our new system. And so I think the reason we should talk about this later is we should try it initially because it might not be as onerous as we think it is. I think part of it is just getting that measure of the difference between what we've gathered, what we have in our system versus what gets reported. I think once we do that analysis, we'll have a better sense of how challenging this might be.
Yeah, and again, I kind of wonder, just on the same point, since they're already doing a demographic survey when they register, then how hard is it to add the categories to, it's the same kind of question back. It's like, how hard is it really to add the categories there to collect it when they do register? And then we can focus all of our energies on making sure they register from the school standpoint as best we can in collaboration.
And the behavior change would be the initial registration and coming back each year. And there's many things that we do on an annual basis. For the attorneys in the room, we come to the State Bar every year and address our licensing requirements. And this could actually be preparing the students to do that for the future.
Yeah, that might be sort of the very collaboration we need, right? To make sure that we have the demographic data that we need. We may need your help in ensuring that they're registered. And so let us take a look at that, sort of our numbers versus your numbers and see what's matching up. But we may need, if we're going to take on that sort of the ownership of the data, then we may need your help in ensuring that registration happens.
Right. Yeah, I don't think anybody in the room objects to trying to do that.
So that's one piece. And then the second piece that stands between us and lunch is that same sort of data applied to the annual report. This year we got more questions than ever about the time period, even though the time period hasn't changed. Annual report looks at data through September 15th, 1 year through September 15th. But because some schools have multiple starts or different starts these days, including one that starts right after September 15th and therefore did not have any of the first year class in their data, we'll be again looking at that start information as well as the class cuts. We've found some schools that this year have started to take their year-long classes and they don't award a single grade, they award 2 separate grades. So the annual reports will be changing in reflection of the new rules work that CS BARS is doing, but we will be reaching out to the schools prior just to really understand your starts, your schedule, your courses, so that our instructions can be clear on the annual report. Just wanted to make you aware of that and also to help you to know that as we understand that better, it also helps us to figure out our capacity to do things internally with the students.
And I just, on this agenda item, I wanted to ask what other questions came in about the annual this year? If you just have a few examples off the top of your head. I know the period is confusing because the form changed a couple of times. It must have been a response to questions, but what other kinds of things?
This year, the reporting date was on a Saturday, and so we attempted to point that out to make it clear. It cleared it up for some, it confused it for others. A second change was to add a fourth year to the 6061 disclosure. And we wrote down, the schools are used to a year ending September 15, but the public is not. And so we translated the year ending September 15, 2019 to the 2019-2020 school year, which is how the public would see it. The question we got back from some schools, particularly with new registrars, is, are you looking for a prospective report? Because we will have several starts during the school year of 2019 to 2020, unlike most ABA-approved schools. And the State Bar can ask rigorous questions to the schools, but we cannot ask you to predict the future.
Good point.
So we added a line on the 6061 to clarify the translation between the reporting year that we've used and what the public expects and understands. And if I would have made a slide to show how you can prepare that. It's a lot of numbers.
Can we either now or at another time talk about the reporting year question? Because you actually have two separate standards. The 6061.7 standard is a statutory standard.
Correct.
And it drives an annual calendar year basis report. Now, in the annual report world, we have the September 15 reporting year standard. And I gather that you don't like the difference between those two because you've asked us to have our 6061.7 ready in time for the annual report in an email that I think we all got. So what is the bar's direction on those two? One is statutory, not much we can do about that. Are you trying to move the two to the same? Moving to another kind of reporting year, so from, it doesn't make it better.
As a practical matter, most schools report their 6061 in January, the statutory requirement, using data for the full year ending September 15. So most schools have all of their reporting queued off that calendar year ending September 15. This year, we included the 6061 along with the annual report because we went back to the future. Until last year, that was included with the annual report, and we got a lot of requests to include it again. Most schools liked having it at that time. A couple of schools said, we need a little bit more time. Reason being, we give our students till the end of the year to report their employment outcomes, and employment outcomes are only on that 6061 statutory disclosure. So the vast majority did like it. A few needed a little bit more time to get that employment data and give the students to the end of the year to secure a JD Advantage job and have that counted.
Okay.
So the year historically has been through September 15. There is no plan at this point to change unless we receive feedback, but that's a discussion that should be had.
Okay, all right. So the annual reporting year is not expected to change. And the 6061.7 is also not expected to change. We know that, but.
Not at this time.
Okay, all right. But I was just trying to make sure it was clear because it was a little bit, that part confused me in the annual reporting season this fall, so.
Okay.
All right.
And so I would say that, right, as we've been saying with the accreditation discussion, nothing's off the table. And so as we're going through developing the new rules, that's the timing of certain things is certainly up for discussion. And maybe what turns out is the timing that's in our rules, the September 15th timing, is the timing that makes sense. And the calendar year timing for the 6061.7 disclosures is what doesn't make sense. So there's certainly an opportunity, if that's what we all conclude, for us to try and seek a statutory change for that timing. So I do want to I want to make sure that we're not leaving you the impression that we're closing down this discussion.
No, and I just want clarity on where we were as far as what the plan was. I think that those are all good questions. You have to have a record date so that everybody understands on what date do we count all these things. But whatever date that is, probably it's a range of possibilities that would work for that. Appreciate that, Tom. All right, staff, that's it for the 1 and 2 on the staff report?
And that's really my suggestion.
Okay, great. Well, we will adjourn for lunch. Let's make it a reasonably working lunch because we still have a lot of things that we're going to do today. Why don't we take half an hour or so and then reconvene? Yes, right.
Just a question, am I a voting member or not?
You are now.
Okay, because I mean, the website says that one of the CBE appointees, and I understand the CBE appointee, may be a non-voting consultant with expertise in accreditation issues. So I just wasn't clear which way I was, voting or not voting.
You are voting.
Okay, thank you.
And this is a new body constituted this year, and at the point of inception, the committee wanted to retain the discretion to decide which, and selected the position as a voting member.
So I've got responsibility.
I'm happy to inform you, or I regret to inform you.
All right, thank you, everyone. We'll reconvene at, and for our online audience, we'll reconvene at 4:10. All right, thank you. Welcome, everyone. This is the continuation of the CS BARS meeting of December 5. Thank you for your patience. We apologize for the slight delay in reconvening. At this time, we will return to our staff report. We have 2 remaining items on the staff report. However, before I do that, let me just pause and ask if there are any public comments respecting these matters. Seeing none. Any online? Any on the phone, I should say? Great. Let's go back to our continuation of our staff report then with item number 3.
Okay, thank you, Greg. Item number 3 is the discussion of format for the registrar's meeting in 2020. So in the upcoming year, the State Bar intends to have a meeting or other forum for registrars. That meeting was set long ago, prior to the internet, and it used to provide really the only means of communication practically with the State Bar about issues affecting registrars. So these days, we now have a lot of things that weren't in place beforehand,
including a person of the day for moral character questions, access to eligibility for eligibility questions, and soon we'll have a point person for questions on aims as well. So we'd like to poll the registrars to figure out the best time of year to hold such a meeting and what the best forum would be. And we wanted to let you know that that will be going out to registrars. One thing that we learned is that historically the meeting being held in October is right before a reporting deadline for many of the registrars at the ABA approved schools, and it's never been convenient for them, but they wanted the information and we didn't know. So we wanted to go ahead and just really get registrars' feedback. And if there are any initial comments from the CS BARs, you're welcome to receive them, but you're not required. Just want you to know that that's coming.
All right, thank you. Are there comments? First of all, from our call-in members. All right, and then from anybody in the room on that one? I just want to say, I do think that registrars really appreciate the opportunity for that direct contact. And so I'm pleased to hear that the bar is continuing that, but just revisiting how it might go about. I do think they appreciate getting peer knowledge shared to a certain degree in those meetings as well. So, All right, so then, the last item on our staff report is update on recent developments.
There are no specific recent developments that have not already been agendized.
All right, very good. We then move on our agenda to, excuse me, an item that is a charge of this committee, which is to make a recommendation for members to be appointed to the Moral Character Working Group that is presently conducting, I've attended a couple of meetings and doing some very good work in thinking through the processes around how moral character is evaluated by the bar. That group is comprised of a number of different folks from a number of different constituencies and settings, one of which is a California accredited law school. It was a member of that committee was a California accredited law school dean, and that individual has retired, and therefore there's an opening on that moral character working group specific to a California accredited law school dean, at least in the past. And so we have received applications for that position, and this group has to make a recommendation about a person to take that position or recommend among the possible candidates a person to be appointed to that group. So let me say that we have a couple of terrifically qualified candidates, and as a result of the fact that I know both of them, I personally will abstain from any vote on the matter. We will be conducting the vote. I hope others will be able to do so. And what we have traditionally done is not conducted a public discussion of qualifications on these matters. In other words, it's certainly worthwhile if the members of the CS bars have a strong objection to an individual. But what has evolved as a process is that the chair of the CS bars has made a recommendation, and that recommendation has been put to the group for its approval or dispute. And if the committee will indulge me, I'll share with you the chair's recommendation for this, and then we'll see if there's conversation around it, but we'll conduct our vote. I'm not the chair. I'm not recommending. No, I'm not saying this is my position. This is, in fact, our chair, Jackie Gardina, reviewed the candidates and recommends Dean Myron Steeves for appointment to the Moral Character Working Group. And so what I'm looking for at this stage of the game is a motion to approve. If there are comments or discussion, we can certainly entertain that. Just try to keep in mind we don't want a very public discussion of detailed qualifications of these both of these fine candidates.
Well, I've moved to recommend and appoint Myron Steeves to the Moral Character Working Group.
All right, is there a second?
Second.
So is that, who just identify, is that Marty? Is that Dean Pritikin?
Sorry, that was, yeah,
Okay.
sorry.
Dean Pritikin seconds. And is there any discussion? Are there any, so let's do the roll call vote on this if we could. That way folks can abstain when it comes around to them.
Sure. Okay, Greg Landis,
Abstain.
Brian Brazil,
Aye.
Graham Ballora,
I'm going to abstain from this just for the fact that I would prefer the deans make this decision as opposed to me.
So, Kareem, the one thing I might add though is we have to be sure we have a quorum in order to conduct a valid vote on the matter.
By the point of order, as long as we have the voting members present,
Yeah.
it would be
Okay, fine, perfect, thank you.
Great. Oh, under that circumstance, Mr. Gongora, abstain?
Yes.
Greg Murphy?
Well, I'm actually abstaining too, and I mean no disrespect to Jackie Gardina's recommendation, but I just don't. Both the people who've been recommended to us seem to be have excellent resumes and qualifications, and I just can't decide between them myself, so I'm abstaining.
Martin Pritikin?
Aye.
Jay Frickberg?
Aye.
And for formality, Jackie Gardina.
Okay. Congratulations, Dean Steves, and thank you for your service. All right, so next up on our agenda is the work that we will do for the remainder of our time today on developing some recommendations for the new accreditation rules. I will only tee this up very briefly by saying the work that's come before has been a process of evaluating what values we hope that the accreditation rules accomplish. And the work that's being done now is to take those values, and begin the process, at least of translating them into the rules of accreditation. And so with that context for what we're doing today, let me turn it over to our very able staff person, Natalie Leonard. Natalie will take it from here.
Greg, I'll bring up the presentation. And for those who are following along online, this presentation is also posted on the CS BAR's agenda. Okay, thank you. So the CS BARS has been working on this project for a while, and I'm just going to turn off my prior mic to avoid feedback issues. CS BARS has been working on this project for a while, and because we have a new member, I will quickly review the steps to bring him up to speed, though I can confirm that he has done his homework. We began by looking at the grayed out bullet point 1, which is adopting recommended values and principles that will guide state bar accreditation. And that work product that the CS BARS created, that was presented to the committee by your member Kareem Gabora, has been warmly received both by the committee as well as this body, thinking about it in retrospect after the meeting. And that draft work product will now be used to guide the rules that will flow from those values to make sure that the accreditation process does reflect and does measure and does evaluate the values that guide it. So just quickly, the progress that has been made to date is the following. In January, the Board of Trustees adopted the edict that asked the State Bar through the Committee of Bar Examiners with input to look at accreditation, and we'll look at the detail of how in just a slide or two. CS BARS was a brand new body at that time. A call was made for members in March, and the committee began to meet in April. Greeted in April, and then in June, we reviewed a history of accreditation and foundations for this project. In October, met twice to identify the values that undergird the purpose for accreditation. And here we are in December, beginning the process of translating values into rules, which will be begun today and continued in 2-member teams after this meeting concludes. To refresh you, this is the mission statement that was put together at that time. It has had minor edits based on the feedback directly from CS BARS, primarily involving punctuation, but it looks much like the mission that was crafted back in October. Does anyone have any questions about this slide before we move on to where we'll spend most of our time with values? When we were last together, the CS BARS created a draft working values list that looked like this. At that time, in order to think about a way to wrap one's arms around all of the concepts you were discussing at once, we attempted to use the accreditation framework, dividing the categories into mission, materials, measurement, and moving forward. There was a lot of agreement about these values, possibly the list being too large, but the values, yes. But also, many members pointed out that a number of these areas, the number of these values didn't fit into just one box. Or sometimes there was controversy as to which box was the right one. Therefore,
We've removed the boxes. So this is the same list that you had here, just boxes removed. And then this is the list that we'll work with today. So we wanted to talk about a process moving from these values to what the standards and rules could look like going forward. And in preparation for this meeting, I met with your chair, Jackie Gardina, and your acting chair, thank you, Greg Vandis, to discuss a proposed process that might be realistic and helpful for CS bars to use to proceed. And what we propose is the following. For each one of those values, now this chart applies to each value individually. The task for CS bars going forward will be to look at the value or the batch of values that you've selected and to determine what is the purpose of accreditation in this area. What is it that the state bar wants to present to the law schools and to ask the law schools to do in effectuation of that value. The second question will be, what are the regulatory steps or actions or inputs that should be required of law schools? Third would be, how can this be measured by the law schools, by the state bar as well? And also, how can we ensure that there is a continuous feedback loop, if that is indeed appropriate, to make sure that the schools continue to evolve and incorporate best practices. Are there any questions about this process? Or Greg, would you like to make any comment about this process before we
Has joined the conference.
Well, no, I think you've covered it well. I think the kind of categories there are helpful analytically when we think about what a regulation is attempting to do. Is this a regulation that is about measuring something? Is this a regulation about encouraging, for example, innovation or creativity? Is this a regulation that serves the particular mission? I think we want to reflect the values in a variety of different ways in different types of regulations that accomplish the different purposes.
Mm-hmm. Yes. And so we put together a couple of examples that were put together offline. They are completely draft. They're open to your feedback, but we thought it might be helpful to see some examples before we get to creating a work plan for the drafting. So these were the inputs we found most helpful in the trial run. The first one was to look at the related rules of other accreditors. So the CS bars got together and looked at the mission and value statements of a number of institutional accreditors, as well as a number of programmatic accreditors. And what I would offer to you as staff is to provide to you the relevant regulations if an accreditor has similar regulations in that area. If you prefer to work with the source documents, I will provide the source documents to you as well. And you'll see an example of where we did that. And I'm hearing a clicking in the background. I'm not sure if it's coming from feedback on our side or if someone on the telephone might need a mute.
Make sure to mute their head.
Oh, thank you. Whatever happened, it's better, so thank you. Okay, next is a format that we suggested to make sure that you add the elements that are unique to the law school context. And then look at the current rules and guidelines to see if there are relevant pieces in there, or also if there are pieces that may not be relevant going forward. And then finally, this will always be informed by the input that's been received along the way from the committee, from the schools, including CS bars, as well as staff. And then hopefully we hope that this will help you to translate the values into rules. So here's an example. We're going to look at the values related to diversity, inclusion, equity, and access. So let me start by saying I understand that these are 4 different concepts. They're different from each other, they have different strategies, and in particular, access was one that people felt could belong in a number of different areas. So consider this a draft for process. It can be refined later. So the first thing we did is look to see how other accreditors measure diversity. The State Bar accredited and registered schools are opportunity schools, but with that said, we haven't done a lot of work previously in measuring exactly how you bring that opportunity to fruition, though we feel certain that we'll find that you do. But other accreditors do have specific missions, and we look to see what they are. So in the area of architecture, and actually, I'm talking a lot. Do we want to round robin, and maybe we could take turns reading them? Does it feel like they're great?
Well, folks can certainly read them from the slides. We don't have to actually read them aloud, probably. But,
Okay.
I would say, Natalie, is there an appropriate moment at which we should take public comment on this particular issue in the broad sweep of the staff presentation? Would it make sense to pause at some point for that purpose?
Well, would you like to pause at this moment because we've laid out a framework and we can get an initial reaction? Or would it be more helpful to go through an example?
Why don't we do the example, well, the first example, and we'll pause. We have two examples, I think, so let's do the first one. We're still talking, folks, everybody, sort of about the process of taking a value and translating it into some kind of language with reference to benchmarks. That's where we are right now. We're looking at some benchmarks from other professions, and then we're taking a look at how that might work. Those concepts might be brought in based on our values or not, depending on whether those things have an attraction or not, as a way of achieving a rule that would be appropriate to reflect the values that were identified. So that's the sort of the position, and now here's an example of how that could be done. By no means is done, but could be done.
Mm-hmm. And so the first thing to notice is that each accreditor has handled this in a different way. Perhaps one of these, perhaps some of these, perhaps none of these will be right for State Bar accreditation, but I think it's helpful to see other frameworks, see other language that's being used today, especially because this is a new area. I would ask the members if we are ready to proceed to the next slide, if you've had a moment to look these over. Okay, the next thing we did was we went back to our striped slide, and now we'll use it for yet another purpose. We're looking at the law context in specific, just determining, okay, so now we've seen some examples. What are some of the ways this could start to work in the law context? What are some of the additional features we might want to look at? And so on that first line, you'll see the beginnings of a potential rule or standard that could be a part of the new rule set. And we indicated, and Donna was foreshadowing this a little bit earlier, schools must create, implement, and monitor plans to recruit, retain, and prepare for licensure in California lawyers from a diversity of backgrounds, perspectives, and life stages. There is nothing final about this rule. It's open to discussion. It's just something to get discussion going. In terms of materials and methods, you might consider a specific plan for diversity and inclusion with respect to students and faculty, type of resources that are appropriate for the students that the schools are admitting. And that might vary by school because each school might have a different mission, different type of admissions profile. And taking affirmative steps to foster open and respectful dialogue. That's important in creating an inclusive environment, but also that's an important legal skill for practice as well. In terms of measuring it, how could it be measured? Well, we can look at things like enrollment, attrition, and graduation by demographic category or other categories that are appropriate for the school's stated mission. We can look at student satisfaction. You may have other ideas. And having that data, we think, could help the schools to continue to improve their plan. So these are some of the things that we brainstormed. And then it turned into a rule that looked like this. I feel a little bit like I'm on a cooking show. Or I'm about to take the finished, though it is by no means finished, cake from the oven. I'm going to make this larger so that you have a hope of reading it. So actually, let's look at it small so you can see the structure. It's got a rule up at the top and the beginnings of some enabling guidelines beneath it. Okay, is this large enough to be of use to anyone? Because this piece is not yet on the webcast, though it can be so placed on the agenda after the meeting. Greg, did you have a?
No, I was just saying, might zoom out just a hair, because we're losing the last end of the, just a hair, losing the last edge there. Perfect.
Okay, so sometimes between the grid and the rule, you find you need some other things to get ready, and this rule is a combination of the legal requirements, which are not something that we set within CS BARS or the Committee of Bar Examiners, as well as the stated mission from the prior page. And so the question to ask is this something that the State Bar should be interested in as a result? Is this something that can be asked of the schools in a way that makes sense and is consistent with the mission that you're carrying out? And can it be measured?
Natalie, do you just want to walk through, before we open it up, you want to walk just through the other pieces there for a second so people can see what, so for example, 4.1 essentially says what we already have as a requirement, that schools have to have a policy. 4.2 is more in the active measures to promote diversity kind of sort of category of language, which brings in some of the concepts that you saw on a slide previously from other professions, the ideas from those standards from other professions, professional school regulation, I should say, come in as, again, just as an example of a drafting exercise here in 4.2. And then 4.3 likewise has the measurement that the school has in place, these recruitment and retention activities and other things to achieve mission-appropriate inclusion. Mission-appropriate inclusion being an important part of the phrasing that comes from, again, some of the other professions, because a particular school may have a particular mission in mind as it goes down the road of doing its recruiting and including the way it considers inclusion.
So for example, a school could have a special emphasis on working adults and might provide childcare in the evening or meals in the evening along with classes to make it easier for students to attend. Another school may have a different student body profile.
And by the way, those notes at the bottom just reflect that most of these items are actually already somewhere in our rules or guidelines, or they came from other particular spots. So that when you look at the document, you can sort of see where things came from. Well, with that example, again, of the process of taking values, filtering them kind of through benchmarking to translating them into a draft, now we should perhaps pause and take public comment.
Sounds perfect, Greg.
All right. So, having said all that, if nobody says anything, I'm going to be really disappointed. But let's go to our call-in group first. Is there anyone on the phone who has public comment on this very particular matter we've just described? Okay, hearing none.
So this is, sorry, someone else is going to talk first. I don't want to cut them off.
Marty, we're going to get to the committee in a second. I just want to go around on public comment first.
Sorry, okay, fine.
Okay, thank you. So hearing none on the phone, anybody in the room wish to make a comment? Dean
That's fine.
from People's College Law. And step up and please use the microphone.
Oh, all right.
That is provided at the.
Is it on? No.
It probably. Yeah.
It's on. Yes? Yes.
Now it is, yes.
Okay. What I just read up, I don't see it right now, but the schools should operate in accordance with and comply with the Constitution. This might sound heretical, but I don't think that makes sense. For instance, Article 1, 2, and 3, how would this law school comply with that? Then if you get to the Bill of Rights, well, does that mean that the law school would, in the scheme of the Bill of Rights, would be analogous to the government? I hope not. Or would be analogous to an individual. I don't think that, and this becomes a rule by which the law school has to comply, a rule with which the law school has to comply, and that sounds a little, that doesn't sound right. It doesn't sound right. Could we be, have a certification in jeopardy if we don't comply with the Constitution, or in the case of our school, which is not certified, could we get in some regulatory trouble? I never saw this before, and it's the first moment I saw it, and I said, whoa, it just rang a few bells, and come on, because it worked.
Okay, thank you very much. Are there any others? All right. Well, at this stage, let's engage with the CS Bars group on the process that we've outlined a bit as well, as a means of taking values and translating them into the beginnings of the framework for the new rules. Are there comments? Marty Pritikin, I think, Dean Pritikin, you were the first to comment.
Yeah, I mean, I was going to comment on the substance of what was in front of us, not so much the process. So if it's not right, I'm happy to hold off on that.
All right, let me come back to you then when we get to the substance of the example.
Yeah.
On the process at the moment. Any comments? All right, there being none, why don't we then proceed? Go ahead. Yes. Dean Patel.
Acting chair, I don't know what to call
Yes.
him. Well, I think if I'm understanding it right, and you're taking what we all discussed as the missions and the overriding values, and now you're trying to put words to that to create rules and guidelines for us, right? Correct? So I think the process is good. I thank those of you who spent the time to do this. We're not being expected to vote or approve rules today, are we, on this kind of notice?
That's right.
Okay, so no, I think the process so far looks fine.
All right. No other comments on the process? All right. So Natalie, when would we want to have conversation on the content of the examples? Probably not now, probably a little later?
We can do so.
Let me put the mic on. It's expected that after this day, you'll be in teams of 2 drafting for presentation at the meeting in January. And I'm also going to propose the possibility of an additional interim meeting in March in order to present a product to the CBE in April. And so toward that end, I think it would be helpful to lay out the framework, and to the extent there remains time in the day, to discuss the substance. This was a companion to the holiday turkey after a period of study by the chairs and myself. So I definitely wouldn't consider it a finished product, and would accept comments today or also during the homework period.
Okay, well then, let's proceed with the remainder of the presentation, and then we'll catch some time to, Dean Pritikin, we'll make sure we save a bit of time at the end to actually look at a few comments, at least on the substance of the examples. And again, I would emphasize, this was just an example of trying to show how you might go from one to the other. There's by no means a desire that this is exactly what the rule should be.
Mm-hmm. And it's also quite possible that you'll create what are essentially puzzle pieces, and there may be bridges in between. So things like staff inserting the statutory requirements for pre-legal education, and we know that that stitching together of the quilt will need to happen. Okay, the second one that we looked at was preparation for licensure / bar preparation / sound program of education. So the first thing we did was to look and see what other accreditors said about that. Well, of course, no other accreditor has a bar exam because other areas of practice don't have that. We looked to see what other schools do, and with respect to medical schools, we looked to see what their requirements were regarding board certification, and also talked to some of the accreditors about it. They said that they didn't personally set a standard because it generally wasn't needed. The market covered the situation, because in most cases at most hospitals, unless there is an opportunity or a great need, the graduates need to have board certification in order to acquire hospital privileges, and so the market took care of that. And so there wasn't a specific minimum requirement. In the area of architecture, architects generally work for a period of time before they begin their series of multiple licensing exams that take place over a period of years. And so for those of you deans in the room who try hard to find your graduates who took the bar exam 4 weeks ago or 16 weeks ago, you can imagine what it is like to follow up on students that might be taking their licensing exams for 10 years. It's just too long for them to have standard. Most schools said that instead they tracked retention and placement. So that's not exactly appropriate, but the example is to show you that we'll look to see if there is an analog, and sometimes there won't be, and we'll tell you that. So here, a potential beginning of a rule, a baby start of a rule, could be school. The school graduates students who are prepared to take and pass the bar exam and become licensed attorneys should they decide to do so. We've heard loud and clear that not every person who attends law school wishes to take the bar exam or wishes to practice law. But a bedrock requirement would be that they should be prepared to do so if they should decide to do so now or in the future. So in order to prepare, some suggestions we had were that bar courses would be required, as they are now, but also that there would be a bar preparation strategy, but that's left broad on purpose, so that each school could choose the strategy that they feel is appropriate based on their mission and their circumstance. In addition, a resource appropriate to the student body's needs. So for example, if the school has a large population of English language learners, making sure that they've got that particular type of support that would be needed. Depending on the admissions profile of the school, matching the resources to the students submitted. One way to measure that is, of course, the MPR, the individual exam pass rate and the cumulative pass rate, other type of statistics you might note, and the ongoing evaluation of results that you do all the time. And time to go back to the cooking show format. So this doesn't quite match yet. There's probably another piece that needs to be added there, but this pulls from the current rule. Law school must be governed, organized, administered so as to maintain a qualitatively and quantitatively sound program of legal education. The logical addition would be designed to recruit, retain, and graduate students who are prepared to become licensed in California, should they choose to do so. And then here are some possible guidelines that could flow from that. Setting up an organization that will allow this, making sure that there are sufficient sustainable sources of funds to carry out the mission, and a sound program of legal education, with the hope being that the requirements would be clear and prescriptive, but also flexible. bar exam studies, learning experiences that support the acculturation of program graduates, and this gets to a point that Member Pertil has raised a couple of times, making sure that we have practitioners who are civil, professional, and ethical. That have the skills to perform not only today, but in the future as the practice evolves, but have the bedrock for exam topics and professional responsibility because they need that to get started. The competency requirements that were successfully introduced a couple of years ago. And also, I'm not asking you to overpromise. You are not the guarantor of the student's eligibility to take the examination. There probably would ultimately be other issues, other elements here, of course, the NPR. And making sure that there's a written academic program. Any questions about this one?
So again, I would just highlight, if you could scroll to show the footnoting. Once again, what you'd see is that the majority of the concepts are already embedded in our rules or guidelines in some place, in somewhere or where or another that are represented here. There's certainly additional new ideas in there that are not already somewhere, but the notion would be many of these things are not new concepts, they're just gathered in one place as opposed to being scattered in a number of different spots. There are already, I think, 3 or 4 references to the requirement that a law school provide a sound program of legal education, and it comes up in different contexts, that phrase. This draft gathers those together in one spot as opposed to in a list in one place that defines what a sound program of legal education looks like. So the majority of that is not new stuff, it's collected from various places.
Also notice another attempt that we made here is to create guidelines, but also not to dictate how the school operates. Not to require specific strategies, because one specific strategy may not be appropriate for every school. So we're definitely writing this from the point of the regulator, but also looking at it from a 30,000-foot view so that it would encompass the range of schools that we have in California and the range of strategies, all of which result in success for the different schools. And so when you are in a team drafting, think about not only what happens in your school, but what's going on in general pedagogically. So that's our second example. I don't know if you want to take further comment at this point or discussion of this item.
Well, again, we're really kind of talking about process at this stage of the game. We'll talk about content of any ideal or any rules as we go along over time. I guess I should just say, you're offering a second example on another topic, and that was just to have a couple of ways of going about things. Was that useful or not particularly in any fashion?
Well, this is Brian Brazil. I think it's pretty much the only way we can really do it. I mean, unless we go down each and every one of the current rules and guidelines and see which ones need to be amended to be more in line with what we've already now recently stated as what we've known to be our goals and mission. I suppose if we're going to do an entire revamping of all the rules, we want to recategorize things and put them all in one place, and I think the process you're embarking on is probably the way to go.
No other. Okay, Greg, go ahead.
I have all sorts of this is the first time I've seen it, so I have all sorts of things going through my head, and I don't want to get off the track, but there's a lot of work to be done here.
I have a question.
All right, so yes, we'll take a question.
Okay. This is on process, not the content. Process, not the content.
Has the committee looked at other similar rules covering similar subjects? Of other, I think there aren't any for other states, if I'm not mistaken, but ABA and countries that have legal systems that are similar to ours, Canada, Great Britain. Maybe there's others. I guess there are in New Zealand. They may have some very good rules that could apply to them.
So I'll just respond quickly on, there's been a lot of research done. The CS Bars Committee actually looked at a lot of comparative accreditors. That includes the ABA and others as well. That part was considered. This rule is the perfect example because in that it describes the sound program of legal education with certain particulars. That's exactly the approach that the ABA standards take to describing certain aspects of a program, that it says you must have these things. There are lots of other things that might be possible, but there's sort of a list of them kind of in one place. And that was the approach to actually take it in drafting that. I think it's 3.3 here, was to try to find those things from various places and put them in one spot. So it does actually reflect the kinds of strategies that at least that other accreditor had used in writing rules. Go ahead.
Well, I don't think this is exactly the process, but I think it goes to our public comment. Given what little I know about the California registered and accredited schools and their characters and their purposes, I think caution is in order in terms of how much you require of schools in light of what the market may take care of efficiently itself. So, the market actually does some of the values that are incorporated in some of these suggestions. And I know these are just suggestions subject to a lot of amendment. But you're right about the ABA. It has a lot of inputs. In my view, some of them should go away as a matter of academic freedom and the like, and I would be inclined personally to go that way with these sorts of things. Because the more rules you have, the greater the cost, and that's going to have an impact on the affordability opportunity for the kind of students that you want to be admitted in these schools and taking their course of study. So that's just a general philosophical point, but we have to be careful about doing too much, because if you do too much, then you actually, in my view, unintended consequences, you start to restrict opportunities.
When we were doing this practice exercise, one thing that we noticed is that generally the number of inputs that the State Bar was seeking was generally reduced.
Good.
Yet, at the same time, more focused and more informative.
Yeah, we can talk about individual rules, but that's a caution. Schools, given their resources, need to have flexibility, and the more rules you put in there, the more burdens you place on them, the more difficult it is for them to accomplish the mission.
Well, I would only echo that, but also let you know, Greg, and since you're new, there were statements very early on in my tenure here, coming to these meetings, even by the executives from the Committee of Bar Examiners. I think someone even said, should we even be, accrediting these schools? Shouldn't we just let the marketplace decide which schools are better? So I think those issues are uppermost in people's minds of what we do and what we don't do, and I really appreciate your bringing that to our attention.
I apologize. I'm new here, so if I'm just...
I'm congratulating you. You're seeing already what's been discussed here. This is your first meeting, so I'm welcoming your input.
All right, are there other comments? Let me particularly ask our folks on the phone from the group. Okay. Natalie, why don't we proceed to the next part of this, which is
Marty Pritikin.
Has left the conference.
So,
Okay, should we give Marty a moment to come back?
Sure.
framework for this part?
Okay, yes, I certainly can. In sort of informal conversation with staff, it occurred to me, and I'll take the blame for this one, that possibly the next step is to look at the values for those that readily present themselves as things you can write rules about, and then things that are really more reference points, things that we need to be sure that whatever rules we do put into play,
Has joined the conference.
welcome back, are effectuating those values. So in other words, we might not write a rule that says a school must have a flexible mission, right? But we would want to be sure that the rules themselves don't confine the missions of the schools, because we want that diversity among the different kinds of schools. So maybe that's one that goes on the list of, we're not writing a rule to reflect that value. We're in fact just making sure the rules we write do reflect that value. It becomes a kind of a litmus test or a benchmarking standard for the rules that are actually prepared. So this next little exercise for the committee is to look at this list of values and try to categorize the ones that we don't want to write, or we don't think we should write a rule about, but rather we should have as reference benchmarks in the fashion I described. And kind of categorize all of these items in one bucket or another bucket. Excuse me. Now, in the examples that we saw a minute ago, that was just work between the chairs and Natalie to look at things we thought it was pretty clear people would want to rule about. Probably want to rule about diversity and inclusion in some kind of rule anyway. Probably want a rule that says schools are exam related in some fashion. So we gave those as examples, but they might not even be ones that people agree should be on that list. All of these are kind of on the table for us to say, we need a rule about this, we don't need a rule about that. They can still be values, they're still reflected in the mission statement. They just don't necessarily have to translate into a specific standard that is then an enforceable standard against the schools.
And so to help with the discussion, what we started to do is to take those values and try to see if we could craft them into rules ourselves. This is not meant to be a final list either, but it's to show you where we got stuck, and we'll be interested to know if you did as well. And when I say stuck, I mean just thinking that maybe this doesn't lend itself to a rule, the way that Greg was describing. So we started with a slide on the top, and then you'll see each item here one at a time. We tried to think about the ways that we could talk about them and what made sense. So the first one, consumer protection and public good. Consumer protection is at the heart of the State Bar's mission. This is likely to give rise to the rules and potentially in an umbrella way or as a standard itself. And here's something that we suggested, and I wonder if others feel that this is a good topic for a rule, whether or not this is the exact wording. And I apologize, I was trying to make it as large as possible, and every time I made it larger, it jumped. Can we see it?
Yeah.
Oh, I made it jump bigger.
And Natalie, this isn't on the webcast, but our members do have it, right?
Only through this PowerPoint.
I don't think I've seen it.
I don't have it yet.
No,
Only
it's only
looking
through,
at it.
it's through this, this.
Okay, so
Sure.
are we getting that on the webcast so that our members can also look at it, our members who are online?
Oh, the members who are on the phone did receive this document.
The members, that's what I was trying to make sure.
Yes.
Okay,
I'm sorry, I thought you meant the physical members here.
okay,
But the
all right.
phone numbers do have this.
okay, great.
So do you want to take them through just sort of one at a time to brook discussion as to each one and which one should be assigned forward?
Yes. And you have some notes at the bottom of the page, which are brainstorming reflections among that, the staff and the That is in the, sorry, I apologize for that. You don't have this. I have some notes, excuse me, that reflect the brainstorming conversation. So, consumer protection, the public good, as Natalie indicated, it strikes the majority. Natalie, can we actually put that list back up? Is that all right?
Sure.
We should, since we're going through the list, we probably should. There we go. Consumer protection, public good, in some fashion, it would seem that some part of that is reflected in a rule, but it's a great example of why we need to talk about this, because it might be that we think consumer protection needs to be addressed in a rule, but public good does not. In other words, do we expect the schools to serve the public good in some regulated way? Or are we mostly worried about regulating their consumer protection? And we'll bounce whatever we do against public good. We're not abandoning it as a value. We're just not writing a regulation about it. So that's an example of why the conversation should evolve, or how the conversation should go. Do we think there ought to be a regulation about it, or do we think that it is something that is really more of a guiding principle against which we test the regulations? And you can split them.
This is Jay Frickberg, if I could jump in on that one.
Yep.
I think that they're similar but different. I think the majority of the rules guidelines right now are consumer protection. But I think as an example, the ones we were just discussing as diversity, inclusion, equity, access, those are all public good. They're all for the public good, not consumer protection. So I think we will have some rules and guidelines that will drive off of the public good discussion.
Exactly. That's exactly what I was asking, because I think we will definitely, and we'll bounce them against each other. But we are not going to write a regulation that says law schools must serve the public good. You see what I mean? The difference?
Well, is it?
Yes, yes.
Yep.
When you're talking about consumer protection, I think you're primarily talking about prospective students and existing students. If you're talking about public good, you're talking about society at large. There are those who argue that for example, a diverse student population is important for consumer protection for the students. But those say, no, you don't have to worry about that. That's more of a public good that we need to be concerned about. And when you're talking about the public good, you're talking about society at large. So I think when you're talking about diversity and inclusion, I think you're talking primarily about the societal good. I recognize that there's value in education and having diverse student populations. But once you start going down that route, then you've got to start measuring it. And then measuring it means you have to make certain decisions on what complies and what doesn't. And again, I don't know what the population of the schools who are not ABA accredited look like. I suspect they're pretty diverse. That's my suspicion. But when you start imposing, or not imposing, when you start writing rules along that way, you're going to start to have measurements. And then what policies decision are you going to need? If you had a school that was in a particular neighborhood that served a Korean population, it wouldn't likely be terribly diverse in terms of ethnic, but it would serve the public good. How do you deal with the accreditation under those circumstances? I don't know.
And I'll say that I found when doing this homework to prepare for this meeting and looking at consumer protection, I knew it was core to the State Bar's mission, but I also did find that many of the things that I thought I could put against this as a rule did show up in other places. So in the student-centered area and faculty resources, et cetera, I saw that as well.
Yeah, again, I'm not arguing against it, but I'm thinking you could find a school that had a strong, it's almost completely dominated by one ethnic group, and you'd say, well, geez, that's really not a diverse student population. But the public good is served because actually that school is producing that, people who may become lawyers that have that ethnic background. Yeah. So there's some tension there, and as you incorporate that value in the rules, recognize that you better, and you mentioned this before, the flexibility, but you better make sure that you aren't requiring each school to be ethnically diverse in a particular way if that doesn't reflect what's really happening on the ground.
Are there other comments?
I would just say that I think all the rules together that we end up with serve the public good, and that's the whole point. We're trying to be ethical, professional schools. We don't mislead anybody. That to me is the consumer protection part. Students know what they're getting into. They know what they're taking on and what the school takes on. And that's clear. That's disclosed in the very beginning, and they know what they're signing up for. After that, I think we'll go back to the too many rules might come back to haunt us kind of approach. And I don't know that you have to outline or specify anything about what public good our business does, like any other business that's honest and treats its customers well. We're all serving the public good that way.
So it sounds as though the committee consensus to this point is sort of, we recognize there will be rules that are consumer protection rules, and we recognize there's rules that will be related, of course, to the public good idea, but we're not writing a regulation that tells law schools must have a mission that serves the public good, or something along those lines. Is that the census? That's the sense of the committee I get from the comments. So you see, I'm trying to get a nice tidy list, right? I'm trying to get two lists. One list is the ones where we gotta go write a regulation about that thing. And then the other one is, we know there's regulations that relate to it, but we're not writing one specific to it, at least at this time. That's where I'm headed. So if I'm reading it right, we have, this first one is split in two. Consumer protection goes in the category of, yeah, we probably need some rules that are specific about consumer protection, but public good is one that we'll use as a reference value. That's the sense of the committee?
My sense.
Anybody think otherwise? All right, there's one. Now we go to the next list, which is got 6 different words in it, so we can. Yes, go ahead.
Question, how are we doing the public comment? Are we just waiting till the questions come up, or?
No, it's a great question. It's a very good point. We are doing, right now, we're doing a sort of a community conversation about this. And it would make more sense to have our public comment, then have our committee conversation. So I think we should pause and take any public comment about these values and how they should be broken apart into those 2 categories that I've outlined. So ones of which there ought to be a regulation specific to that, to implement that value, as opposed to other values which might be reference values, by which we test regulations to ensure that they don't disserve that value or that they promote that value. So that's the specific point on which public comment at this stage of the game is welcome. Do we have any folks dialed in? And do we have any folks in the room? And please identify yourself for the audience, if you would. Forgot to ask that earlier.
Myron Steves, the Dean of Trinity Law School. It seems like the first one bears a really heavy burden here. I think implied in consumer protection and the public good is, does the institution deliver a sufficient quality legal education, however that's defined? And apart from where I see transparency as a value, that there's a lot of good that comes from regulations that mandate disclosure of a lot of data. It seems frustrating to me, but looking through that list of 10, I'm not sure that if you work from those outward, you necessarily get as an end product the definition of what the minimum standards of a law degree are. And I wonder if the way through it isn't going to be doing something that's not stated, and that is having an internal definition of what a good law school looks like, figuring out what that is, and then referencing back to filling in the details of those 10 points. Because I think the only real reference point to that is going to be consumer protection. And I don't know if the better step isn't to go back from these 10 to that as a foundational issue. Is there an expectation of what a legal education looks like? That might be going down a different channel from this.
Okay, thank you for that comment. Do we have another?
Yeah.
Be sure to identify yourself.
First is, consumer protection, that's.
Please be sure to identify yourself on the tape.
all
I
right.
failed to ask you that earlier.
This is Ira Spira, Dean at People's College of Law. Consumer protection, as I understand it, as I recall, I mean, is taken from the state bar's mission. And, well, it seems to me that there needs to be a clarification in the term as used for the law schools compared to how it's used for the state bar. Because the state bar, I think it means, I'm pretty certain, protection of clients. It certainly doesn't mean that for law schools. Conveniently, there is a category of people who fit the definition, obviously students and prospective students, but I think it should say that. Protection of students and prospective students. Somebody could interpret it to mean, well, the schools should focus on protection of clients when these people become lawyers. Maybe it should, but it's a different thing. I think it should, actually, because the ethics rules and that sort of thing. All right, secondly, the public good. Let's see. Oh, yeah, all right. I don't think it's, I think it could be controversial to say, it sounds odd, but I think it would be controversial to have a rule that law schools should support the public good. Here's what I mean. And I think there should be such a rule. Here's what I mean. I can imagine, I think I know some people who have a kind of a libertarian point of view, and they would say, no, I want to learn this profession, and I'm not going to use it for the, quote, public good. I'm going to use it however I see fit within the law. All right, so that's how it could be controversial. Now, I say back to that point of view, no, this is a regulated profession, and it's regulated for the public good. And so there should be rules about the public good in, I don't know what rules, there should be a value for the public good that governs the law schools. And I tend to think there's probably places for rules, a place for rules to promote the public good in these rules that govern law schools. For instance, promoting the legal ethics rules. Those are clearly for the public good, I think. And there's probably other examples.
Okay, thank you, Dean Sparrow. Are there other comments? All right, thank you, everyone. So we'll return to our list of items, and again, the two categorizations that we're talking about are, should there be a rule, again, we're talking about the accreditation rules, the writing accreditation rules, on that particular item. Now, taking into account our public comment, of course, I think with reference, our first public comment with reference to what a school needs to look like. What does the State Bar need to regulate in order to accomplish a school that is effective as a law school? So move to our second item. And at least with the conversations between the chairs and staff, between the chair and staff, I should say, and my input, it seems there probably would be a rule written around number 2. We presently have some standards we illustrated as an example, but that might not be the sense of the committee.
I'm not exactly sure where we're at.
Well, we put that, we need to put that back, the list of items back up on the, if we could, Natalie. There we go. So it's the access, inclusion, diversity, equity, and elimination of bias values, which this group generated. And again, the exercise is, do we need a regulation that enforces that idea, or is that just something we're going to use as a reference point? I guess I should say that even the things that are in the category of we'll use it as a reference point don't go away. They're not unimportant. And even the things things we're going to rule about are reference points for other rules, but we're talking about which rules we need to draft. Which rules do we need to draft a rule about this one?
And then the drafting will take place outside of the meeting.
I thought the public comment we received from the dean may have gone, but was a good one in terms of, where we should start on these issues. But on this particular one, access, inclusion, diversity, and equity, it's one thing to say you should comply with the law, applicable law. And frankly, I thought you made a good point on the Constitution. We could say a law school should comply with all applicable laws, but then why do that? Because then that becomes an accreditation issue when there are plenty of other forums to deal with those issues. And on the discrimination, I'm sure that California has anti-discrimination statutes on the books, and you do, and so I'm not sure if they apply to individual private law schools. I suspect they probably do. If they do, then why do we need an accreditation standard? Because if you include it, then that means you've got to have an enforcement mechanism. You need to look into it and need to enforce it. And is that what we want for these categories of schools? I mean, it's laudable. I mean, I just think the additional burdens on the staff for looking into that, examining it, and then is accreditation a proper form to resolve these issues? So if someone makes a complaint about discrimination, whether it's ADA or racial or ethnic, is this, that is often an adversarial proceeding where you call witnesses and the like, and for example, the ADA, it's an individualized assessment many times. Normally, accreditation is not a good forum to have those decided. On the other hand, it's laudable, and you could argue that you shouldn't have an anti-discrimination standard or you shouldn't have an affirmative action standard is to be politically incorrect, but I'm just thinking, does the market accomplish that for you anyway, for these categories of schools? And I don't know the answer, I'm just pointing out the question, is how much do you want to take on and put on these schools?
Other comments?
My only comment about this group of goals or values, I would agree with what Greg Morgan just said about the first four. The last one, elimination of bias, elimination of bias is a little broad. I'm not sure what that means. If you mean among all the professors, among the staff, among the students, that seems to me to be, again, a laudable goal, but really difficult to measure and understand as a rule. And it seems to me out of those five, the only one that you could actually recommend or create some sort of a rule for that isn't already the law in California. I mean, you could ask all your teachers to take an implicit bias test or something on the computer. I guess that's my comment.
Are folks who are dialed in, are there comments on this one, on number 2? Okay. So it would seem that on this one we have sort of a division as to whether a rule is needed or not, or Kareem, do you have any comment on that one, on that question?
I don't. I am interested in the consensus on this. I think I want to hear more from the public than framed an opinion at this point.
And I think possibly in the interest of time, what we want to focus on here is do you see enough promise and appropriate content in the topic that it should be studied to see if it is amenable to a rule? Only because we have about 15 minutes to get through the homework, and that certainly wouldn't be enough time to discuss the full substance of any of these. After 6 hours of meeting, we got to this amount of values, and we wouldn't expect that the committee would pare it down in just 50 minutes.
So would it make sense, Natalie, at this stage to pick a few on which we know we need to draft rules and move to working on those? Would that make sense at this stage then?
It's almost just really a thumbs up, thumbs down on whether it's worthy of further study during the homework period over the holiday. And so it might be that, for example, in the diversity, access, inclusion, not all of those elements may go forward, but it might be something that's considered, and then at the end of the analysis, no, it's not appropriate, or yes, these elements are appropriate content for a role. And I think the factors that people are bringing up are the lens through which the exercise will be conducted. Can it be measured? Should it be measured? What is the burden to measuring it, and what is the value to measuring it? Is the value of the exercise? And so is this topic of sufficient value to put it through those paces and bring it back to the committee saying, it didn't make it, or we've done this work and we think it did, and here's what we propose. What do you think?
With that lens, I would like to see this continued on.
This particular item.
Yeah.
Yeah, continued. Okay. Mr. Murphy?
I hate to go back, but the second sentence of consumer protection will maintain appropriate resources, provide an effective affordable education in a sustainable manner. That means the creditor, you need to look at the finances of the school. Do you do that now?
We do.
Okay.
Yeah, I think again, that's some drafting, and again, people will differ about exactly how that should play out in the language.
Yeah, I think I read that.
Yeah, yeah.
And the ABA has one too, it's standard 202, and it's spent a lot of time looking at the resources, anticipated resources and the like, and I just wasn't clear how far you went to qualify.
Yeah.
I mean, it's certainly appropriate because for consumer protection to be looking at the resources of school, you're taking the students and taking money up front, and then they'll look like they're going to close their door in a couple of weeks. That's not a good situation.
But as you say, you then have to develop a standard for what is and what is not sufficient, and that's very difficult in this.
Right.
This particular arena is very difficult to accomplish that. So. Well, all right. So through the lens of continuing further study on whether a rule should be prepared for it, again, back to the list of values. Through that lens, then, are there any of these that we can say we don't think we think there should be, just in the interest of time, any that we would take off the list for further study?
I can tell you from the homework, I'll give out an initial proposal to see what you think and why. Challenges for us were flexibility of mission. We wanted the schools to have mission flexibility, but didn't want to mandate their mission be flexible. Affordable legal education, because the state board cannot mandate the fees that you charge, and affordability is relative, given that this year I think we had the first ABA-approved law school top $100,000 in total tuition and fees. So I would propose flexibility, affordability, preparation for the future, and civility, and pursues excellence. Those 5 were challenging, and I'll mark them so you can see the ones where it was challenging.
Well, wouldn't creativity sort of fall in that same boat?
Yes. So those were the ones which embodied important elements, but the elements seem to fall elsewhere or not be the embodiment of a rule.
Well, flexibility of mission is one I identify myself as being, well, how does that actually work out in practice? And just for example, the question I had before about if you had a community in Los Angeles, do you have a large Korean community in Los Angeles that tends to cluster in a particular area?
Yes.
And you had a law school that wanted to open there, and our mission is to educate people of Korean background.
And there is, in fact, a law school that was centered in Koreatown for many years doing exactly that.
Okay.
A registered law school.
So now they would dad would probably suggest that, geez, they have a lot of Koreans, but they don't have any African Americans, and so it's not a diverse population, yet they may be contributing to the side of the whole. But the flexibility of the mission allow that to occur. So you know, I mean, I'd be in favor in that sense, but the problem is then you have regulatory, how do we enforce this in an effective way?
Yeah, so you put your finger right on the issue. If there is a regulation written that encourages diversity, inclusion, all the rest of that,
right,
it cannot constrain the flexibility of mission. That's the notion of these values are in some degree at war with each other, the way it ends up being expressed.
Exactly.
Yeah, and we're not abandoning anything we're taking off this list. It's still there as a litmus test against what we do leave on the list. But the idea of the exercise is to say, well, which things actually need a regulation that will be tested against those other values as well. And perhaps some of these things just don't need a regulation.
Well,
that was the question for the group.
Or that the regulation may be subsumed under another topic, or may undergird all. So for example, affordability is in the statute and is key to the schools, but rather than having its own rule about affordability, it's a testing, the litmus test against which you bounce all.
Yeah, regulations that aren't enforceable aren't very good. And regulations that conflict with each other are not good. Because if they're in conflict, then you have real enforcement problems. So, you know, I don't know how to balance those out in language, but maybe we think about it for quite a while. But particularly in diversity, inclusion, and then even affordability, it's a tricky thing. I would think the schools primarily want to deliver a good program of education where they teach Anglo-American doctrine. Well, and actually in California, obviously, you've got Spanish influence community property, but you get my point. We want to teach people the norms of the profession, the ethical rules, the substantive law, so they may be prepared for licensure if they want to seek licensure at an affordable cost.
And I would endorse that as the only one we need right there. I'm not kidding. I mean, that's exactly what we need.
Are you on the microphone?
I should be. I mean, that's what we do. That's what we say we do. The more we talk about this, the less enamored I am with the whole idea of rewriting all these rules and having so many things we can't or may not be able to enforce. And it's all about, most of which is already required of us by law to run a legal law school, to disclose what we do to our students and do everything we can to create and produce ethical, competent lawyers who, if they want to be lawyers. There's not a lot more that you need to say.
So I'll make a suggestion that you might consider, that if we were to remove the topics with the XX, leave the topics without, we might have a framework that does approximately that.
No, I'm hoping that that's what we end up with. Something that's relatively easy to deal with. And we don't have a lot of duplications.
That's the nature of the exercise. Which ones do we take off the list of rules to draft?
Well, then isn't the question is what is the committee, and obviously ultimately the state bar and maybe the Supreme Court, what's the function of these schools? I mean, what is the core thing that you're trying to accomplish? Maybe you have some for-profit schools, and their mission is to make money for shareholders, but for owners. But you know, what is it that California really wants these schools to be accomplished? It strikes me from the outside coming in, what my thought was that you want for a legal education at considerably less cost, so you open up the opportunities for people who otherwise couldn't go to law school.
Right.
And that's what it's about. We don't have to have a lot of faculty and publishing, you know, and law reviews. We just need to deliver the educational experience at at the best price possible, reaching the populations that wouldn't otherwise be able to do it, whether it's ethnic or age or socioeconomic status.
And that latter point actually drives, the latter point about reaching the populations drives a great deal of this policy, I think, as well. One of the big challenges, and the ABA has just made this much worse, is the exclusion of people who don't fit a certain socioeconomic profile, because there is a very direct correlation between socioeconomic status and performance on regulatory exams. And they've just made that much worse. They're putting out of business all these law schools that serve more diverse populations as a result of their change in standards. So to your point several times today, caution is warranted. If you want to achieve the purpose of these schools, the regulatory burdens that you impose on them can actually put them out of business. And they're putting schools out of business left and right, as of right now, as a result of changes in their regs. That were schools that served those populations more broadly than others. So it's become a very challenging environment for schools that have a very diverse student body.
Yeah, you must be talking about Stand 316.
Yes.
And of course, the Department of Education has been pushing for quite some time for outcome measures. And for law schools, one of the most important outcome measures is how many of your graduates are being licensed to practice law. Because that's why most students who go to ABA accredited law schools, they want to. That's why that measure is a significant part measure to happen with the price of a law school and ABA accredited law school, what it is these days, particularly when you weigh in the tuition discounting system. A lot of people who go to law school where the data indicating that they will likely not be admitted, and I'm not fully understanding the cost. I mean, I thought that the point, one of our public commenters said, disclosure is the key, particularly for these kinds of law schools in California, where you have this very high minimum passing standard. The more you can tell the students that this is what we're about, and this is what the data show, the better you fulfill that consumer protection function.
All right, so we have been at this for quite some time. Why don't we take just about 5 minutes for a biological break at this stage of the game?
Does the chair need
Really, just 5 minutes, and then we'll return and continue the conversation. Both of our members, Dean Pritikin and Dean Frickberg, on the line. Okay, hold on a second. We've got Thank you, Tom, for muting and then unmuting. Okay. Deans Frickberg and Pritikin, we still have you on the line?
Yes.
Yes, thank you.
Okay, and I haven't gone to you for a while in this conversation. Comments or thoughts about these items we've been discussing? Neither of you are shocked.
No, I'm in concurrence with what we were saying as we were going through the meeting. The big issue being as it relates to the affordable legal education. I don't know how we can make a metric for an actual rule or guideline, and the flexibility of mission. 4 and 5 on slide 17 are the ones I would have the most trouble with in our current discussion.
Okay, thank you. Yes, 4 and 5, yep. That's flexibility of mission and affordable legal education for everybody. All right. So what we would like to do is choose a few of these, in our remaining time, a few of these on which we will begin our drafting exercise. And the idea is that during the time between now and the next meeting, we would work in groups of 2, let's say, to converse about the nature of a regulation to implement a particular one of these things, one or more of these things, on which we think there needs to be a regulation. Taking into account existing regulation, by the way, as you saw in the examples earlier, most of those gathered things from various places that already exist. And then also taking into account any benchmarks that the staff is able to provide for us that describe how others may do this in other accreditation settings. So that's kind of the process we've described today. And we would now take it to drafting practice, actually, or drafting outside of the meeting with sort of staff work that we take upon ourselves to be prepared with some possible regulations to consider at our next meeting. So what I'd like to do with some of our remaining time is to work our way toward those possible assignments and who's going to work on what, and which ones of these we would have our subgroups work together on during the time between now and our next meeting, or whatever deadline Natalie gives us. I should say it that way, because Natalie will give us a deadline for our work and our process. Natalie, did I describe that accurately about where we're?
I think that works. Sure, that works.
All right. So let's take the stance for the moment that those that have been highlighted with 2 X's at the end of them are, at least for the moment, off of that list of things that we'll draft on between now and the next meeting. And the other ones, we can assign out in groups of 2 to, say, 2 people to work on 2 items, something like that?
Sure.
Does that make sense? That leaves us with 1, 2, 3, 4, 5 items. It only leaves us with 5 items that we actually are working on. So we've got 7 people on our committee, and we can kind of divvy up our groupings however we would care to, and do a little drafting. Do we have enough time to do a little drafting? Well, not probably today. I don't really, or do we? No, we're going till.
Yeah,
We're going 3:30, right?
We're until 3.
Oh, 3.
Yeah.
Okay.
So, yeah, so we might want to think about some pairs that we might suggest. Quite often, the chair remains unassigned to assist.
And that would be Jackie, or me.
That would be Jackie.
Okay, Jackie, yes.
Good try, Greg.
Because we've got 5, that gives 2 groups, 2 topics, and 1 group 1 topic. One possibility might be for the groups that have 2 topics, they get one of the moderately digested topics that we've already had, either diversity or legal education / licensure, in addition to a fresh one to equalize the burden.
That sounds good.
Yeah. Okay.
So do you have an idea about how we would work the groupings?
I'll make a couple of suggestions. My theory being Kareem and Greg Murphy should be on different teams, either both of which suggesting a committee voice or a committee direction, so to divide the committee input. I would suggest potentially Kareem and Jay Frickberg, who is on our phone line, Brian Pertil with Greg Brandis, and Greg Murphy with Marty Pritikin. What do you think about those groups? Any objections?
Sounds
And
good to me.
then Jackie available to float between the groups. And basically, I'm trying to pair a person who, people who have diverse experience together in one team. And then as far as assigning them out, I believe we have certain flexibility as to that. I have a suggestion, but I'd be happy to defer to the acting chair.
I don't have a suggestion, so why don't we use yours?
Okay. 1, 2, 3, 4, 5. Okay, so I would suggest that that Brian and Greg consider consumer protection and program of learning. How do you feel about that, Brian
I'm
and
wondering
Greg
if,
B?
What's the second one?
Preparation for licensure / sound legal education.
Oh, I thought we took that one
So
out.
we took that one out. That's, oh, no, sorry. Preparation for the future is the one that was taken out.
Okay.
But if you're in comment.
well, it seems to me consumer protection goes well with transparency, if you're giving out 2 topics
Oh, that's a good point.
that are closely related.
Mm-hmm.
I don't care what topics you give us, but
Logical pairings do make sense.
that,
Okay, so Greg Brandis and Brian Pertil, how about consumer protection and transparency?
Now, the only thing I'll say is that we do have some dean expertise on that transparency and evidence-based decision-making stuff. Yeah, well, I think I'm pretty good on that. Maybe everybody's pretty good, but I think I'm pretty good on that. Jay is pretty good on that. A lot of us are. So does expertise really erase it? Should we have expertise base groupings as well, on the topics, that is?
That's a good point, Ben. So let's first say transparency and consumer protection look like a good combination.
Okay.
And then, let's see, we have access / diversity as a pre-digested and preparation for licensure. Reading as the student-centered, I think student-centered / teaching excellence might be a good combination for preparation for licensure. How do people feel about that?
well, I'm sorry, we have, what, 5 topics total? 1, 2, 3,
We do.
4, 5.
So 2 groups will get 2 topics, and one pairing suggested is transparency and consumer protection.
Right.
And then another pairing suggested is preparation for licensure and student-centered / retention / teaching excellence, because those topics seem related.
I'm not objecting to that.
Oh, okay. And then access / diversity being its own. How about that?
So we end up with one group that has one topic that's already been pre-digested.
Mm-hmm.
That's the challenge. That's probably a challenge with that, right?
Let's see. So
Not that they're confined, but
right. So transparency / consumer protection, that has 2 new topics together, but they're quite related.
mm-hmm. So the answer is there's no good way to do this, or no perfect way to do this.
I hope there are
Anyway,
several good ways to do it.
there are several good ways. That's the positive way of looking at it. That's exactly
But
right.
when you have 5, you can't compare 2.
Yeah, that's exactly right. So we could always put one back on the list.
That's true.
For example, preparation for the future, or pursues excellence for innovation, creativity. And then everybody will have 2.
How about, I'm going to actually propose new teams.
Why not put civility, professional ethics with,
Access and diversity?
no,
I don't know, I would suggest.
for like program of education?
Yeah, I would suggest maybe starting with these 5 and see if the others X's fall under.
It's difficult. Why don't you just decide? Why don't you just say what you think is best?
Okay, how about,
I think we're all willing to do what Natalie wants us to do, aren't we? Anybody object?
Well, that's a rather broad statement.
I'm sorry. Yes, in this homework exercise.
well, the challenge is that actually all of you have many wonderful strengths. And so as I look at it, I say, oh, but I also, I think the group would appreciate the feedback of this person from this.
Yeah. Well, of course, bearing in mind, all we're doing is setting it up for a draft that will be discussed at the next meeting. So everybody will have input into the ultimate process.
And the goal is to draft proposed rule or rules
Yeah.
that incorporates those values.
Yes.
Okay.
And the examples given show you that it might be a simple statement, but it probably will have perhaps some other dimensions.
I thought I knew a good list and keep switching them around.
Do you want to give the assignments after the meeting? Do you want to have some staff time to do that? If anybody has strong objection to working on a topic, then let Natalie know now, but.
Can I make a suggestion on the pairing that I think works?
Sure.
Preparation for state bar licensure, bar examination, and civility, professional, and ethics. I think that works because, what you're considering is whether you're going to include as a requirement that the school teach civility, professional ethics, or whatever you're going to put it. And that's, the Supreme Court's always been interested in professionalism and ethics.
Yeah, I agree with that.
So that's a topical pairing.
That's a topical pairing.
Okay.
Then you've got two for each group.
Yep.
So maybe access and diversity and student-centered / teaching excellence might go together.
Yep, sure. And then the remaining ones are consumer protection and transparency, which was already a pairing.
Okay.
Right?
Yeah.
So the pairings are consumer protection and transparency. That's the top of the list and second from the bottom. Then student-centered and teach with encompassing teaching excellence paired with access and diversity. And the other pairing is civility and ethics paired with preparation for licensure or the SOUT program of legal education.
Mm-hmm.
All right, so we got that done. Now let's talk about people and assignments on those different groupings with consideration of folks' wishes as well as expertise.
Are we looking for volunteers for the pairings right now?
Just a second, Jay.
Sure.
All right. Well, I have a proposal. And let me bounce this way. It throws everything out of the window that we talked about before, but now we've got a different set of priorities. So on the consumer protection and transparency, how about Dean Pertel and Dean Pritikin working together on this one? On access and the student-centered teaching excellence, how about Mr. Gongora and Mr. Brandis on that one? And for the preparation for licensure and civility and ethics, Mr. Murphy and Dean Frickberg. How do those pairings sound to everybody?
No objection from me.
Any objections? Any objections, Deans Frickberg?
Nope.
Frickberg?
None here.
All right.
No.
All right, that's it then.
Well, one thing I'll say is I felt very excited pairing up this group, thinking about the talent in the group and the number of ways the groups could combine. So thank you.
It's a very talented group indeed.
Yeah,
So Natalie, why don't you outline sort of the expectations of the process? We've got just 10 minutes or so left, and kind of lay out the steps that folks should go through. We described the process, by the way, for how you might get to a draft by the examples given earlier in the day. So in terms of inside the group when two people are working together, that structure of looking at the reference points, considering how the value might translate, constructing a rule, actually the construct of physically putting it together, numbering schemes, all that sort of stuff. You can just take the examples, we'll circulate those examples, and just build them that way as a starting point. That doesn't mean they'll end up that way. But that gets out of the way, one of the things that you might spend a lot of time worrying about, and then we'll deal with it later on. what other kinds of guidance would you give folks about the process?
Sure. Okay, so what I would suggest is that for each group, also lean on staff to gather things for you. You are here for your expertise rather than your administrative skill or excess time available for administration. So we will automatically put together for you the materials related to what other accreditors are doing in your area from the set that you've already seen. And we can forward those to you next week. In terms of global timing, the hope is to bring back something that can be discussed at the CS BARS meeting on January 30th for ultimate presentation to the Committee of Bar Examiners at their subsequent meeting. The next meeting after January is April. I might propose in there the addition of one more CS BARS meeting in March so that you could see for the first time in January and then refine in March before showing. How do people feel about that global timeline? I'm seeing a
Well, I'll be out of the country for all of March, so, I mean, you can't make the changes for me, but I'm just letting you know I can't make a meeting in March.
Okay.
But otherwise, I should be able, any other month.
Okay. Or potentially late February is a possibility.
February's okay.
I have some March limitations, but we'll just wait and see what you do, what the timing is.
Okay, it sounds like maybe late February is maybe even better, potentially.
Sounds like it.
Okay, and then as far as so that's the global assignment, but the local one is between now and January 31st. In a perfect world, especially because this is a lot of material and you'll want rich public comment, I would suggest that we propose to be able to post material mid-January. So if we could have a check-in with each team, I'd be happy to be included so that we can give you as much support as possible. One day next week can let me know what support you need for your plan and then what works for each group considering the time and your family and holiday plans. The actual task at hand would be to go through this same exercise. Look at the earmarked material for other accreditors or that additional other accreditor that you request, create the law school specific grid, and then translate that into a potential rule. Greg has a lot of experience in drafting and was able to come up with some guidelines as well. And those guidelines served as a double check. So they're not required, but they are very helpful. I think this works. The guidelines confirm that it does. And so if you can go that way, I think that that's very useful. What do you think, Greg?
Oh, yeah. So just the guidelines as a reference point are the place where we have a lot of the detailed regulation presently. And that detailed regulation can be drawn out of guidelines into the framework of these rules, which would mean the guideline then essentially goes away, or the guideline is not required any longer. And so I think that's the process you're describing. And in some cases, that will lead to the elimination of some of the guidelines that presently exist in that form.
And that's a real possibility.
That's a thought anyway.
It's true, and again, it's also possible your exercise may convince you that your topic shouldn't go forward, and that's a possible outcome as well. Any questions or thoughts regarding those next steps?
You provide us the contact information with everybody.
Yes, I will send that out after this meeting.
And let me just remind everybody about our Bagley-Keene requirements. This group work in groups of 2 does not violate any public meeting laws, but you can't reach out to another group of 2. You can't send this around in a group email. You can't contact others on the committee regarding it. Anytime we have a majority of members who discuss a matter, that's expected to be done in a public meeting. And going from 2 to 4 would violate Bagley-Keene. So we're asking you to work in subgroups of 2 on these so that you don't have to work by yourselves, but none of that sort of reach out is permissible within the public meeting laws that we operate under.
But we'll provide 2 pillars of support in that context. Your chair remains unassigned so that a chair can participate with a group. 3 doesn't make a quorum. And also staff can be contacted. You can bounce ideas off of me. You can ask for administrative support. And I'll ultimately coordinate all of your work to be shared next time. So you have your partner, but you also have your chair and staff as well to assist you in this project.
And Caroline, have we forgotten anything we should admonish everybody about?
No, that was a perfect recitation of the rule.
Okay, thank you.
Thank you.
It's difficult to run a workshop and do this kind of stuff without violating those rules, so we just want to remind everybody to be careful with that. We certainly want to comply with those rules at all times, so. All right, so Marty, I promised you that I would have some time for conversation around that particular rule you wanted to comment on, and we have a total of 5 minutes left.
Yeah, no, it's moot. I don't want to waste the group's time on it. It's been superseded by, I think, other things people have said. It's
Okay.
fine.
And so you have my apologies for not
Thank you, guys.
letting you have it earlier.
No, it's fine, it's fine.
When it would have made more sense. Are there other comments or thoughts from the group on our topics for today? Otherwise, I'll entertain a motion to adjourn.
So moved.
And second?
Second.
Second, and all those in favor?
Aye.
Aye.
Any opposed? Any abstaining? Thank you all very much. Much appreciated.
Thank you for.
Thank you.
Jack.
Good job.
Kindly.
Thank you.